Yes, you can.
Thank you.
We're on the record in docket 22-01713. That's people of the state of Michigan versus James Harden. So, will the parties please introduce themselves for the record?
Jake Whiskey on behalf of the people.
Good morning, Your Honor. Toby White on behalf of James Harden. He's joining us by Zoom, as am I, and we consent to a hearing that's being done electronically.
All right, and sir, you are James Harden?
Yes,
And you can hear me all right, Mr. Harden?
yes, I can.
Okay, Mr. Whiskey, this is the time set for a probable cause examination, a probable cause conference in this matter. How are we proceeding today?
Your Honor, my understanding is Mr. Harden just retained Mr. White, I think, a couple of days ago. And Mr. White and Mr. Harden would be requesting an adjournment of the preliminary exam at this time, with Mr. Harden waiving his 21-day rights this morning.
And Mr. White, is that your understanding of what we're doing today?
Yes, it is.
All right. May I inquire of your client concerning the waiver of the 21-day rule?
You sure may.
All right. Mr. Harden, you recognize that you have a right to a preliminary examination within 21 days of your date of arraignment, and I have your date of arraignment as of July 26th. Do you understand that, sir?
Yes, I do.
And your preliminary examination is a probable cause hearing in which the people of the state of Michigan would have to prove by probable cause evidence that a crime was committed and the identity of the person who committed that crime. Of course, you'd be able to contest any of those charges with Mr. White through cross-examination in the hearing, and you're represented by Mr. White. You understand you have a right to have that hearing within 21 days.
Yes,
If you waive that right today, you will still have that hearing. You just won't have it within the 21-day limit. And that's because Mr. White's asked for an adjournment that's been stipulated to by the prosecutor. So that'll put the hearing actually outside of the 21-day limit. Do you understand that?
yes,
Are you willing to waive your right to a preliminary examination only within the 21 days, not your right to have a preliminary examination?
yes,
All right. I find that the waiver of the 21-day rule to be knowing, voluntarily, and intelligently made, and we can reset this matter.
August 18th.
We can reset for August 18th.
Excuse me, Your Honor.
Yes.
From what I do know of the case, I would like one more week if I could have that. I am going to be subpoenaing in some specific records to use for cross-examination.
Be at least like 2 weeks. Right.
The 18th is 2 weeks if we go to September.
They're not going to get those documents back within 2 weeks. I guarantee you. We'll have to go the following week. I'm in a conference,
Okay.
so I guess I'd go the first week of September would be the safest date, Mr. White.
Yep, that would be okay. He's working and he's not incarcerated, and he spoke to me before about how if we had to push it out, he'd be okay with that. I'm okay with that.
All right. All I'm worried about is that I don't think 2 weeks is enough time for the documents to get to you. And so,
Yeah.
And the third week is just a problem. So let's do the week after the conference.
September
All righty.
2nd.
So September 2nd at 8:30.
Friday, the 2nd at 8:30.
Correct.
All right. I have that in my calendar and I will keep my client advised.
All right, Mr. White. Mr. Witzy, anything else for the record in 22-01713?
No, Your Honor.
Anything, Mr. White?
Nothing else. Thank you.
All right, Mr. Harden, we'll see you back here at September 2nd at 8:30. If you have any questions, keep in contact with your attorney, Mr. White, okay?
Okay,
All right. Thank you for your appearance, sir.
thank you. You're welcome.
Thank you, Your Honor.
So Mr. Crino and Mr. Boyd, we're going to call your case as soon as the jail comes in with Mr. Sotelo, okay?
Sounds great. Thank you, Your Honor.
Yeah, thanks, Judge.
All right, thank you, Mr. Crino. Mr. Boyd, are you ready to go on your client, Mr. Sotelo? Mr. Sotelo?
Yes, sir.
All right. So we're on the record in docket 22-01954. That's people, the state of Michigan versus Felipe de Jesus Sotelo. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Assistant Prosecutor Bill Crino on behalf of the people of the state of Michigan.
Good morning, Judge Dwayne Boyd, P79612, on behalf of Mr. Sotelo, who's present via Zoom and consents to this hearing. Please state your name for the record, sir.
Felipe Sotelo.
Okay, you are Felipe Sotelo, and you can hear me all right, Mr. Sotelo?
Yes, sir.
All right, thank you. This is the time set for a probable cause hearing. Mr. Crino, how are we proceeding?
Your Honor, thank you. As the court has correctly noted, this is the date and time set for probable cause hearing in this matter, or pre-exam conference, excuse me. A preliminary examination in this matter is scheduled for August 11th. Your Honor, previously Jared Austin from the Public Defender's Office was appointed to represent Mr. Sotelo. However, my understanding is that Mr. Boyd has now substituted in, and a substitution of attorney has been signed by this court. I had an opportunity to speak to Mr. Boyd yesterday. My understanding is, and I don't want to speak for him, but my understanding is that he is going to be requesting an adjournment of the preliminary examination for the reasons that because of the substitution of counsel, he has not yet received any discovery in this matter. The discovery is extensive, and my understanding is he needs additional time to prepare. Also, I'll put on the record the fact that the forensic autopsy report that was prepared by Dr. Michael Markey has not yet been completed, and we anticipate that's going to be done within about 3 weeks. Your Honor, if in fact a request for adjournment is made here this morning, the people find, or people believe that there is good cause for that adjournment, and we would not have an objection to the adjournment, and we would also so waive our time frame for preliminary examination within 21 days.
Thank you. Mr. Boyd, is that your understanding?
That's an accurate recitation, Your Honor, and I've also advised Mr. Sotelo of his statutory right for a preliminary exam within 14 days of arraignment, and he's willing to waive that right to give defense time to prepare.
All right. So may I inquire your client on the 21-day waiver?
Absolutely, Judge.
All right. Thank you. Mr. Sotelo, you understand that you have a right to a preliminary examination within 21 days of your arraignment, which is July 26th, 2022. Do you understand that, sir?
Yes, sir.
And a preliminary examination is a probable cause hearing where the people would have to prove by probable cause evidence that a crime was committed and the identity of the person who committed that crime. Do you understand that, sir?
Yes, sir.
And you, of course, could contest those charges with Mr. Boyd in regards to representation and in regards to cross-examining any of those witnesses. Do you understand that?
Yes, sir.
It's my understanding today that you wish to waive your right to have a prelim within the 21-day period. You're not waiving your right to having a preliminary examination, only to having that preliminary examination within 21 days. Do you understand that, sir?
Yes, sir. And I agree with
So it is your intent. It is your intent today, and you wish to waive your right to a preliminary examination within 21 days.
Yes, sir.
Any questions regarding the waiver of the 21-day rule, Mr. Crino?
None for the people. Thank you, Your Honor.
Mr. Boyd?
Sentence satisfied.
Thank you. So I'm going to find that the 21-day waiver was knowing, voluntarily, and intelligently made, and I'll reset this prelim. Would you like the probable cause conference reset or just set it for prelim?
Your Honor, my preference, and I'll defer to Mr. Boyd as well, my preference would be just to set this for preliminary examination, and then in the interim, he and I can talk. If there's any discovery issues or other matters we need to bring to the court's attention, we'll do so. But my preference would be to set it for preliminary examination. I would indicate, Your Honor, that I don't think we're going to need much more than a morning or an afternoon. This is not a full day prelim. So I think in looking at scheduling, the only consideration would be when the forensic pathologist report is done. And I'm told it's going to be about 3 weeks from today's hearing. So just as the court is scheduling, we would ask that you take that into consideration. Thank you.
All right. Thank you, Mr. Crino. Mr. Boyd, any comment on that?
I concur with APA Crino, and I'd ask that the court set this, if possible, on September 2nd.
Mr. Crino, does September 2nd work for your schedule?
It sure does. Thank you, Your Honor.
All right. So let's set it for September 2nd at 8:30.
That works with the people.
It works for me.
All right. That'll be an in-person live prelim at this time. And then let the court know if there's any changes to that. Anything else for the record from the people on docket 2201954? Mr. Crino?
Your Honor, thank you. Nothing for the people this morning.
Anything, Mr. Boyd?
Just housekeeping, Judge. I anticipate
All right.
it could possibly be digital discovery, and I was just inquiring whether or not I need a court order to take a laptop into the Ingham County jail.
You do not need a laptop to take you need a laptop to take it here or elsewhere. I'm sorry, I didn't get the full question.
Is there any prohibition of defense taking a laptop into the Ingham County jail without a court order?
Mr. Crino, I'm not sure of that. Do you know the answer to that question?
I see Mr. Abbott shaking his head over there. He's not party to the case, but he probably knows better than anybody. And Mr. Abbott, if I speak incorrectly,
Yeah, I
let me
agree.
know.
Mr. Abbott, do you know if there's a court order needed for defense counsel to take a laptop into the Ingham County Jail?
There is not, Your Honor. He can bring the laptop in with him when he visits.
Thank you.
All right, Mr. Abbott's one of our public defenders, so he'd know the rules to the Ingham County Jail more than Mr. Crino or myself. All right. Anything else, Mr. Boyd?
No, Judge. Thank you.
All right. So, Mr. Sotelo, we have adjourned this to September 2nd at 8:30. If you have any questions, keep in contact with your attorney, Mr. Boyd. Okay, sir?
Yes, sir.
All right. Thank you. That's all for the record in docket 2201954.
Thank you very much, Your Honor.
Mr. Abbott, you're here on Kevin, you're here on Jacob Kelly.
That's correct, Your Honor.
All right. I'm going to call to the record docket 22-01940. That's people of the state of Michigan versus Jacob Leonard Kelly. Will the parties please introduce themselves for the record?
Jake Westy on behalf of the people.
John Abbott representing Jacob Kelly, and we are both appearing by video today.
Thank you. And sir, you are Jacob Kelly?
Yes, sir.
And you can hear me all right, Mr. Kelly?
Yes, Your Honor.
All right. This is the time set for a probable cause conference on the case. Mr. Wisty, how are we proceeding?
Your Honor, an offer has been made. Mr. Abbott was discussing it with his client in a breakout room. So we'd be prepared to enter a plea if you take the offer. I would defer to Mr. Abbott.
Mr. Abbott?
That's correct, Your Honor. He's currently charged with fleeing and eluding third, and the offer is plea to attempted fourth degree with no objection to YTA. And Mr. Kelly has decided to accept that offer.
All right. So that would be a plea to the misdemeanor?
Yes.
The 1 year?
Yes.
Mr. Kelly, is that your understanding of the negotiations today?
Yes, Your Honor.
All right. All right, so there will be, is that an amendment to the count or an added count to? An added count to, Mr. Wisty?
I would do an added count 2 and then dismiss count 1. If you would bear with me one moment, Your Honor, it's got to be under the criminal code.
Okay.
And I wrote down motor vehicle code statute. That's for purposes of sentencing.
Yeah. Can you attempt for? Yeah.
I'm ready to proceed, Your Honor.
All right, so it's an added count 2 of attempt fourth degree, which is the 1 year. And what's the MCL code on that?
The MCL 750.47A.
And it's 1 year, and what's the fines and costs on that?
That would be 1 year and fines and costs of $1,000. And that would be, just for the record, MCL 750.478.9A paren 2.
9A parents 2. Okay. And go ahead.
Paren 1, Your Honor.
All right, parent 1. All right. So, Mr. Abbott, I'll indicate for the record, you're at my understanding of the plea agreement, and then you can confirm it. There's going to be an amended count 2 of attempt fourth degree under 750.479A parents 1, that being a 1 year and or $1,000 penalty. And with the plea to count 1 to the amended count 2, count 1 is to be dismissed.
That's correct, Your Honor.
And then there's a kilobrew of YTA, is that correct?
Yes, Your Honor.
Of HYTA status. So, and then Mr. Abbott, there's also a kilobrew agreement of HYTA status.
That's great. Thank you. Yes.
All right. Mr. Abbott, may I inquire of your client, Mr. Kelly?
Yes, Your Honor.
All right. Sir, you've heard what the attorneys have said in this case, that the offer is to plead to a count 2 of a 1 year attempted fourth degree pursuant to the laws of the state of Michigan, 750.479.5479A parents 1, that being a 1 year and or $1,000 with a kilobrew agreement of HYTA status. Do you understand that's the negotiation with that? You'd be pleading to count the amended count 2, and count 1 is to be dismissed.
Yes, John.
All right. And you understand if your plea is accepted, you will not have a trial of any kind. You'll be giving up the following rights that you'd have at trial. And I'll go over those rights with you. All right, Mr. Kelly?
Yes. Yeah.
Okay, you'd have the right to have witnesses called in your defense. You'd have the right to cross-examine all witnesses. You'd have the right to testify or to remain silent without an inference being drawn from that silence. You'd have the right to the presumption of innocence, and you have the right to require the people of the state of Michigan to prove their case and all elements beyond a reasonable doubt. Do you understand you'd be giving up those rights if you plead guilty today, sir?
Yes, Your Honor.
And you are represented by John Abbott from the Public Defender's Office, and he, of course, would contest or cross-examine any of the allegations made by the people of the state of Michigan. You understand that, sir?
Yes, Your Honor.
All right, you're actually pleading guilty because you are guilty and you wish to make a factual basis in this case, correct?
Yes, Your Honor.
I'm going to have you raise your right hand. Do you solemnly swear or affirm that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth under the penalties of perjury?
Yes, Your Honor.
All right, I'm going to bring your attention back to July 23rd of 2022 at Cedar Street in Hamilton in the city of Lansing, state of Michigan, Ingham County. Were you driving a motor vehicle on Cedar Street in Hamilton on July 23rd at that time on that date?
Yes, Your Honor.
And I have the factual basis, but so as part of the factual basis, why don't you tell me what happened that makes you guilty of count 2 of attempted 4th degree fleeing and eluding?
I was scared because I got flicked and I didn't have a license.
All right, and so what did you understood that the trooper Harshman was an actual trooper and pulling you over at the time?
Yes, Your Honor.
All right, and then what did you do in response to the trooper making sure that you were pulled over?
I fled.
All right, and is that an area in which the speed limit is marked at 35 miles or less?
Yes, Your Honor.
All right. So I find the factual basis to count 1 has been made, so I'll take it as a factual basis to count 2, attempt 4th degree. Any questions, Mr. Wisty, of the factual basis for count 2?
No, Your Honor.
Anything, Mr. Abbott?
No further questions. Thank you.
All right. I find the plea to be understanding, voluntarily, and accurately given. I'm going to direct Mr. Kelly to the probation department. For a pre-sentence. So Mr. Kelly, what I'm going to do is I'm going to have you report to the City of Lansing Probation Department within 48 hours of today. And what they'll do is they're going to have a questionnaire and they're going to ask you questions. It'll go to a report for me so that I'll have a report for sentencing purposes. Do you understand that, sir?
Yes, Your Honor.
All right, so report to the City of Lansing Probation Department for pre-sentence evaluation in 48 hours. And do we have a sentencing date?
September 19th at 9. Or I saw September 19th at 9. Do you want to-
I do via Zoom, the sentencing. So we can do a sentencing via Zoom, okay, on September 19th. What's that? At 9 a.m.
Yes, that's okay.
So Mr. Kelly, make sure and you go and do the pre-sentence at probation. And so they'll be able to prepare a report and we'll see you on September 15th at 9 a.m. Okay? I'm sorry, September 19th at 9 a.m.
Yes, Your Honor.
Anything else for the record, Mr. Wisty in docket 2201940?
No, Your Honor.
Anything, Mr. Abbott?
Yes, Your Honor, you gave him 48 hours to report, so this is Friday. Does that mean he can, if he's done it by Monday afternoon, that's enough time?
Yeah, Monday should be fine, Mr. Abbott.
Okay, thank you.
Yeah, and I'll even put that in the file just in case. So it'd be by Monday, the 8th.
Thank you.
Thank you, Mr. Abbott. So Mr. Kelly, if you have any questions concerning this matter, please keep in contact with your attorney, Mr. Abbott, okay?
Okay.
All right, that's all for the record, docket 22-01940. Thank you for your appearance, everybody.
Thank you, Your Honor.
Thank you, Mr. Wisty. We'll see you, Mr. Abbott. You're free to go. the record in docket 22-00155. That's people of the state of Michigan versus Gustavo Galindez. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Andrew Stevens on behalf of the people.
Good morning, Your Honor. John Abbott representing Gustavo Galindez. He is not here today.
This is the time set for a preliminary examination. Mr. Stevens, how are we proceeding?
Your Honor, the people had received some indication that Mr. Galindez may not be appearing today, and that sort of came to fruition this morning. Mr. Abbott, along with the officer who's in the court, the primary assigned officer to this case, have checked the halls multiple times for Mr. Galindez. At this point, the people would be requesting a bench warrant, any bond posted be forfeited, please. Thank you.
Thank you. And I will indicate for the record that this was scheduled for 8:30 and it's now 9:26. Mr. Abbott, any comment?
No, thank you.
Okay. So defendants failed to appear. There is a bench warrant and bond forfeiture now issued. Anything else for the record, Mr. Stevens?
Nothing from the people. Thank you.
Anything, Mr. Abbott?
Nothing from the defense.
All right, thank you. That's all for the record in docket 22-00155. So, Mr. Jordan, you're here for your 9:30 probable cause conference?
Yes, I am.
All right. Are you represented by counsel today, sir?
Yes, Scott Grable.
Okay, thank you. So stand by and we'll wait for the assistant prosecutor to appear on your case along with Mr. Grable, okay?
All right, thank you.
Thank you. Mr. Grable, you're here on Mr. Jordan?
That's correct. Good morning.
All right, thank you. Good morning. And you'll be filing an appearance with the court?
I did file appearance. It should be in there. I emailed it last week. I can send it again, Your Honor, if I get the
Send it
email.
again, just in case, because we didn't get it. It's not caught up with the file yet.
That's fine.
So I wanna
I'll
make
send
sure-
this as soon as we're done. I'll send it forthwith.
All right. And we're ready to go on this case?
I believe so, Your Honor.
All right.
Yes, Your Honor.
So this is, I'm going to go ahead and call the case, Mr. Grable. This is docket 2201-830. That's people, the state of Michigan versus Mark Jordan. Will the parties please introduce themselves for the record?
Jake Westy on behalf of the people.
Attorney Scott Graham, on behalf of Mr. Jordan, who's appearing by Zoom. We waive our appearance in person.
And sir, you are Mark Jordan,
Correct.
and you can hear me all right, Mr. Jordan?
Yes, I can.
All right, Mr. Wisty, this is the time set for a probable cause conference, and how are we proceeding? It's my understanding, this is another assistant prosecutor's case?
Yes, Your
Okay.
Honor. Ms. Matuska this morning.
So Ms. Matusko, okay. How are we proceeding today?
Your Honor, there's been conversations with the defense counsel about waiving up to this result in circuit court. I don't know what the status of that is, so I would defer to the defense counsel if they're waiving up.
Mr. Grable, what's your understanding of what we're doing at the probable cause conference today?
For today's purposes, Your Honor, I do anticipate later probably waiving the preliminary exam. I did reach out to Ms. Mantusko. She's out till Monday, Your Honor. So I would probably ask the court, if the court wants to keep the prelim on for next week. Again, I don't anticipate the prelim will be held. I do anticipate it's going to be a waiver. This case dates back to 2017. The only thing I want to do is make arrangements to come in and view the evidence, obviously, at the prosecutor's office. If I can do that sometime next week, I have a feeling then we'll be able to waive the prelim next week, to be honest. Other
All
than
right,
that,
so-
Your Honor, that's it.
All right, thank you, Mr. Grable. So I'm going to leave this on for preliminary examination. So we'll leave on for preliminary examination on August 11th at 9 a.m. At 9:30, the prelim set for. And then, Mr. Grable, you'll be in contact with Ms. Matusko concerning any discovery issues?
I will. I'll do that. I'll do that on Monday, Your Honor. There is one condition I was going to bring up concerning one of the bond conditions, Your Honor.
All right, you can proceed as to that, Mr. Grable.
Just very briefly, Your Honor, I did not get a chance to talk to the assistant prosecutor. I did let Ms. Mantusko know I would be seeking at least a slight bond modification. There is no internet usage that was set with the magistrate. And she told me obviously to take it up with your office. The client obviously needs to use the internet just for work purposes. Obviously, I asked him to log on Zoom today, Your Honor. I was not trying to run afoul of the bond condition, but for just court purposes, I figured the court would not be opposed to that. But I wanted to address that if the client could use the internet for anything non-sexually stimulating, as I said, this case, goes back to 2017. Obviously, the client has had internet usage since then. He's been in counseling for the last 5 years. And other than that, that's the only condition I would ask to be modified, that he could allow to use the internet, obviously and he couldn't visit any sexually stimulated sites. That's usually a typical bond condition in these. And this is a possession. It's not a delivery, distribution, or reproduction case.
Any comment, Mr. Wisty?
Yes, Your Honor. Given the nature of this, I see why there were concerns in initial banning of using the internet altogether. I would generally ask this keep in place at least till Ms. Matuska is back. Maybe it can be readdressed next week. If the court is going to grant that, I would ask for just specific limited conditions. You can use it for work, you can use it for court, you
Right.
can use it for counseling, you can use it for medical.
Yeah, this is a 2017 case, so I think this is a fair request. But I will place the limitations in regards to the use of internet on the pre-trial bond conditions. So I will allow use of internet for work, counseling, court, and medical purposes. And then if you want to readdress something more broader, we can do it next week at the preliminary examination. All right, Mr. Grable?
Very good, Your Honor. I appreciate the court's time as well as the prosecutor. Thank you.
All right. Mr. Jordan, we're going to leave this on for preliminary examination on August 11th. If you have any questions, please keep in contact with your attorney, Scott Grable. Okay, sir?
No problem.
All right. Anything else for the record? Docket 2201830, Mr. Wisty?
No, Your Honor.
Mr. Grable?
No, Your Honor. Thank you.
All right. Thank you. Thank you for your appearance, Mr. Jordan. We'll see you next week.
All right,
Thank
thank you.
Thank you.
Thanks. All right, we are on the record in docket 22-00822. That's People of the State of Michigan versus Sergeant Waway. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
And Assistant Public Defender Scott Nickel on behalf of Mr. Woolley, who is present and standing to my right.
And sir, you are Sergeant Waway?
Yes, sir.
All right. All right, Mr. Wisty, this is the time set for a preliminary examination in this matter. How are we proceeding?
Your Honor, my understanding is defense is seeking an adjournment due to some charges against the defendant. The people have no objection to that. I believe it's proven given the situation.
Mr. Nickel?
That is correct, Your Honor. It's my understanding that Mr. White was picked up but Wednesday. There is a new charge of carrying a concealed weapon that he has yet to be arraigned on in 55th. We expect that arraignment to happen today. And in discussions with the prosecution and Mr. White, I think it is prudent to adjourn this preliminary exam and to allow for a global resolution of both files to occur. And I have explained that to Mr. White, and he is willing to waive the 21-day time period to allow that adjournment to occur.
All right. And Mr. Nickel, may I inquire of your client concerning his 21-day waiver?
You may, Your
All
Honor.
right. Mr. Waway, you understand that you have a right to a preliminary examination within 21 days of your date of arraignment, and I have that as of July 22nd. Do you understand that, sir?
Yes, sir.
And part of that is the preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that there's probable cause to believe a crime has been committed in this file and probable cause of the identity of the person who committed this crime in this file. You have that right within 21 days. Do you understand that?
Mhm.
Is that a yes?
Yes, sir.
All right. If you waive your right to a prelim within 21 days concerning what your counsel has asked for, then you'd only be waiving your right to that time period to have it within 21 days. You would not be waiving your right to an actual preliminary examination. Do you understand that? Right. Is it your intent today, and you're represented by counsel, Mr. Nickel, is it your intent today to waive your right to a preliminary examination today in this file?
Your Honor, I believe you asked if it was his intent to waive his right to a preliminary examination.
Yeah, within 21 days.
Oh, yes, sir.
Okay, perfect. All right. So with counsel present, I find that your waiver of the right to have a prelim within 21 days to be knowing, voluntarily and intelligently made will reset this to be outside of that 21-day period. As the attorneys discussed, there is another case out there. And so they want to talk about a global resolution concerning these matters. So a new date for prelim
August 18th at 8:30.
would be August 18th at 8:30. Anything else for the record on this file 22-00822 from the people?
Your Honor, I would just inquire what the court's policy are on bond in situations like these. There may be a violation of the offense, and it would be as a PR bond.
Well, yeah, I don't know what the other case is. So, yeah, so I'm not, so, and I'm not part of the arraignment on that. So I'll leave bond the same in this file. This is a 2-year flee and elude, and then I'll entertain any bond once we find out about the other case. But your client was picked up yesterday, I'm assuming.
He was picked up Wednesday.
And he has, and have they set bond on that file?
He has not been arraigned yet.
Okay.
The arraignment should happen today.
All right. So I'll take a inquiry into bond next week. All right. Anything else for the file on docket 22-00822, Mr. Nickel?
No, Your Honor.
All right.
Just that if a copy of that notice could be printed for Mr.
Yeah, and we'll do it right here. Mr. Waway, if you have any questions concerning the appearance for this date on August 18th, Mr. Nichols, your attorney, please keep in contact with him, okay? All right, thank you. That's all for the record, docket 22-00822. in docket 22-00112. That's people of the state of Michigan versus Kevin R. Jackson. Will the parties please introduce themselves for the record?
Morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
And Assistant Public Defender Scott Nickel on behalf of Mr. Jackson, who was present and sitting in the jury box.
And sir, you are Kevin Jackson?
Yes, sir.
All right. Mr. Pfeiffer, this is the time set for preliminary examination. How are we proceeding today?
Your Honor, people prepared to proceed to examination today. There has been two offers actually made to the defendant, and the defendant, to my knowledge, has rejected those offers. I'd like to place those and have the defendant reject them on the record.
Okay, you may proceed.
Thank you, Your Honor. In this case, the defendant is charged with 7 different felony counts, including 2 counts of unlawful imprisonment, interfering with a crime report by committing a crime, that is a discretionary consecutive case, assault with intent to great bodily harm by strangulation, domestic violence, 3rd offense, assault with a dangerous weapon, and interfering with electronic communications. And he's charged with all of these as a habitual offender, 4th offense notice, making the first 5 felonies life offenses, and the other ones with maximum punishments of up to 15 years in prison. Now, the guidelines, as estimated, if found guilty as charged, are 62 to 228 months in prison as a minimum, with a discretionary consecutive of, I apologize, because I want to make sure I'm saying accurately, a discretionary consecutive of 43 to 152 on top of that, making his potential exposure 105 months in prison to 380 months in prison. The offer from the people was for the defendant to plead guilty to count 3, count 4, and count 5, and that we reduce the habitual offender notice to a 3rd offense notice. That would bring his guidelines to 43 to 114, cutting the minimum end of it by a 1/3 and the tail by half. And additionally, making the fact that these are life offenses be taken off the table. Or the option was given for the defendant to plead guilty to those same counts as a habitual 4th offender, but the people of Killebrew to be sentenced in a 34 to 134 guideline cell. The people also gave the offer for the defendant to plead no contest in either one of those situations, as opposed to pleading guilty. It is to my knowledge that the defendant has rejected those offers, and I'd like that rejection to be placed by the defendant on the record.
Mr. Nickel, you're familiar with the 2 options that have been provided to the court concerning negotiations. It's your understanding that your client has rejected both of those offers.
That is my understanding. May I inquire of Mr. Jackson?
Absolutely.
All right, Mr. Jackson, you and I have discussed the offers that have been made, correct?
Yes, sir.
And you understand, as Mr. Pfeiffer just stated, that your potential exposure, if this case is taken to trial and you are not successful, is 62 to 228 months, or if the judge chooses to discretionarily consecutively sentence you, possibly 105 months to 342 months on your minimum sentence. Do you understand that?
Yes, sir.
You understand that the offers that have been made would reduce your minimum sentence from down to 43 months to 114 months, or in the alternative, 34 months to 134 months.
Yes, sir.
You understand that as charged, as I have before, most of the felonies that you're facing are possible life offenses.
Yes.
And that this offer could possibly reduce, so if it's a half 1/3, it would reduce the maximum sentence to 20 years.
Yes.
Okay. And knowing all of that, is it your intention to reject the offer and proceed with the preliminary examination today?
Yes.
Do you have any other questions of me prior to doing that?
No, sir.
All right.
All right. So both offers have been made and rejected for the record purposes. Are both parties ready to proceed with the preliminary examination?
People are, Your Honor.
Defense is, Your Honor.
All right. The people can call their first witness.
Your Honor, the people will call Christina Lee. It's written as Villa. That is going to need to be changed to Christina Rendon. I believe that is her proper last name. And the only thing that I'd like to address before she is brought in is the location of the defendant.
Would be your preference to have him next to counsel?
It would, Your Honor.
It would be my preference as well.
All right. So for the record, let's move Mr. Jackson next to his counsel. That would work better for Mr. Nickel anyway, to have access to his client.
I thought so, Your Honor.
And you may call Miss Sheldon, Miss Rendon to the stand.
I'll go grab her once.
Right.
I'm sure.
Committed to correct it on record. We'll address the name she gave.
Your Honor, she is in the restroom. As soon as she comes back up, she will be joining us in the courtroom.
Okay.
It's not anything to waiting for her in the hallway, so he knows to tell her to come in here as soon as she's back up.
All right. So is it Miss Rendon?
Yes.
I'll have you come up here and stand right here. Okay, raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? All right, ma'am, I'm gonna have you spell your full name for the record.
Kristie, middle initial L. And then Renner Hart.
Okay, thank you, ma'am. You can have a seat. I'll just have you to speak up as loudly as you can because the mic isn't for projection, it's just for recording, okay?
Okay.
Thank you. You may proceed, Mr. Pfeiffer.
Thank you.
And Mr. Jackson, you can sit down.
Good morning, Ms. Rendon. I'm going to ask you some questions about what happened last November, and what I'd like you to do is answer as honestly as you can. If I ask you something about something you just simply don't know, please just say that you don't know. And if I ask you about something that you're having difficulty remembering, I don't remember, I'm having trouble remembering, is a perfectly valid answer at the end of it, okay? Between November 9th of 2021 and November 15th of 2021, were you living at 4612 South King,
Actually, it's 4620.
4620.
South Martin Luther King.
Oh, is that apartment 2?
Yeah.
Is that in Lansing?
Yes.
Is that in-
4910.
Is that in Ingham County?
Yes.
Now, do you know a Kevin Jackson?
Yes.
How do you know?
His sister is my best friend.
And at some point, did you have a dating relationship with this man?
Yeah, we were seeing each other.
On November 15th of last year, near that location, did you make contact with police officers and speak with them?
Yeah, I'm not sure if that was when police were called regarding the assault, because there was a few times that I spoke with officers throughout that whole time period. So, but yeah, I did.
Before I get any further, would you be able to recognize Kevin Jackson if you saw him again? Do you see him in the courtroom today?
Yes, I do.
Could you please identify where he's located, something about him differentiates him from the other people in the room?
I'm right here to the left. You can do this.
Okay, now there are 2 individuals that you point towards.
On the very end.
The very end, furthest away from me.
Yes.
Your Honor, if the record reflect that she has pointed to and identified the defendant.
Any objection?
No objection for the purposes of preliminary exam.
All right, without objection, the witness has identified the defendant.
Thank you. Now, between November 9th and November 15th, did Mr. Jackson live with you?
No. He never lived in my apartment with me.
Was he trying to stay there?
Yes.
And how are you dealing with that?
Just trying just to keep him away from me.
So you didn't want him being there,
No.
and you told him as much?
Yes. Several times.
Now, during this time period between November 9th and November 15th, were you at this residence with Mr. Jackson?
Well, he frequented everywhere around the apartment complex, and so yeah, I would see him every day, and just show up or.
During this time period, did he assault you?
Yes,
What can you tell us about what you remember of that?
I just remember him grabbing hold of my neck.
Grabbing hold of your neck.
Yes, and it was out in the parking lot of the apartment building. And
Did that impact your ability to breathe?
well, yeah, I don't remember, like, I must have blacked out for a hot minute because I don't remember, it's.
So it actually affected your consciousness?
Yes.
And that was the day that the police actually talked to you?
That was the day that they actually, the care program and LPD came, yeah.
That
That's,
was-
there was a female that lived in the building next to me that called.
And that was on November 15th?
Yes. Because, I mean, there was like 4 or 5 months worth of just nothing but, just terrorizing me, harassing me and stuff. So the dates, I mean, it was just,
When you say terrorizing, harassing, are you talking about by Mr. Jackson?
yes,
And does this include him being physical with you
yes,
against your will?
yes.
At some point between November 9th and November 14th, were you held in your apartment against your will?
Objection, Your Honor, leading question.
I'll sustain it.
I will rephrase it.
Rephrase.
I don't.
I-
don't.
Please don't answer the question.
Okay.
I'm going to ask you.
Okay.
You said during this time period he assaulted you?
Several numerous times with broomstick and his hands. And all
He used a
that stuff.
broomstick? At some point, did you think about calling the police?
Oh, yeah,
Did you try to?
yes, several times.
What happened?
Just you would grab my phone and break it, or, just not allow me to move to do it. Step outside or,
So
just get away.
I want to go back a second. You said he wouldn't allow you to step outside.
I mean, that.
How would
yeah,
what would he do to
Just-
stop you?
Block me from going out.
So he'd physically get in your way.
Yes,
And you're trying to get help at that point.
yeah, I didn't know what to do. Busted down 2 doors in my apartment that I had to pay for, and got lots of just damage that I had to pay for.
Now, when he was putting his hands on you and he was hitting your broomsticks, these weren't something you wanted to have happen, right?
No,
These were against your will.
yes,
At some point, you tried to leave the apartment to get help and he physically stopped you.
there's on several occasions.
Several occasions. This is over November 9th, November 14th.
Yeah, I mean, I don't know, October to December. I don't, it seems like it was later than November, what'd you say, 15th? It seems like it was later than that. but-
Is it difficult remembering the exact date that these things happened?
Well, yeah, because there were so many things that happened within, 4, 5, 6 months that,
That is perfectly understandable. And I do appreciate you being so honest with this court as opposed to trying to,
Objection, Your
I will
Honor.
move on.
Just bolstering the witness.
At some point, were you able to leave the apartment?
yeah,
And where did you go?
what do you mean?
Once you were able to leave the apartment away from Mr. Jackson, where did you go?
Well, the one particular time I went to my cousin's and spent the night there, and then we met home the next day, and he was in my apartment, and everything was gone. They had everything away, clothes, everything except for my bed and my clothes, my shoes, everything.
At some point, did you return back to the apartment from a party store?
Yep, that was when I made contact with the care program and that was what this.
So what can you tell me about when you got back to your place from the party store?
I just remember walking down the sidewalk, walking into the parking lot. And I think I might have been walking with someone, I can't really remember, but he just grabbed a hold of me and choked me, and then I don't remember that I was on the ground, and
At some point, did you try running away from him? But I mean, when. in
that
this
particular
specific
moment,
incident,
no,
yes.
I couldn't.
Do you remember if he initially had anything in his hands when he got back there? Did you have your dog with you?
Always.
And what kind of dog is that?
Control.
And is this a service animal or just a pet?
Well, for a PTSD. She's not, licensed.
Now, Chihuahua, was this just walking alongside you or were you holding it as a small
Hold
dog?
her all the time.
Was the dog still in your hands when he grabbed you by your neck?
No, the dog wasn't in my hands.
What happened to the dog?
I'm not really sure. I think she either went back inside and the door was open, let the door open, or I don't remember honestly.
Do you remember if Mr. Jackson said anything about the dog?
No.
Now, this moment where he had his hands around your neck, was this in the parking lot or back in your apartment?
In the parking lot, but it's happened in the apartment also, but that particular time.
And do you remember roughly what time of day this was?
It was fairly early, before 2,
So was before
11-ish maybe.
So I want to be clear, are we saying between 11 a.m. and 2 p.m.?
It was around 11.
So around midday?
Yeah,
Just to make sure we're talking about 2 a.m.
right, no.
Now, at some point, he stopped choking you. Do you know why?
There, people started.
Objection, you're under speculation.
I'll rephrase. I'll draw.
Sustained.
What did you observe happening around that area when he stopped?
There was a man, 2 women, and I just, then someone picked him up. And yeah, I mean, it was just, the police were there, like, super, things happened sometimes.
They said there was a man and 2 women. What did you see them doing or hear them doing?
Well, the older lady is the one who called the police, and then it was her daughter, and I don't know who the guy was there. She actually looked at me and she said, if you don't.
Objection, your honor, hearsay.
Response?
Your Honor, I'm going for the impact on the listener, not as to the actual truth of matter asserted. It goes to her mental state.
I'll sustain the objection.
So what were you saying?
Um,
You said that the older woman.
Oh,
Said.
yeah, she actually looked at me and said, if you don't. talk
Objection,
to-
your honor, I think you sustained the
I
objection.
did sustain the objection.
I 100% misheard you, Your Honor, and I apologize. for that.
No worries. The objection.
Otherwise, I was not going to ask the same question again. But there were other individuals there,
Yes, I don't know their names or anything. I don't know.
and it was the middle of the day.
Yeah, I mean, it was, I think it was late morning.
So- You said that he got picked up in a car.
Mhm.
So
Said
once,
Yeah, but that's a yes.
Yes.
Okay,
sorry.
thank you.
so once he stopped choking you, he had left. How did you feel? What was going through your head?
I didn't know what was going on. It just happened so fast. There was no warning, no nothing. I literally walked to the party store and came back and boom, boom, boom. So,
Did you suffer any injuries as a result of this?
not, I mean, what do you, as far as being choked?
Over the course of these days, the assaults by Mr.
Oh,
Gadd.
yeah, I had bruises all over the back of my legs from the broomsticks, handprints on my legs, and yeah. Mhm. I mean, I have pictures of all.
When you went to the party store and came back, did you have a phone?
Mm. Yeah, actually, I think I might. Yeah, I don't remember. But I mean, I did have a phone and it was smashed, so I don't know if it was my phone or if I had it right at that moment, because it happened several times.
Okay, so I want to make sure it's clear. You don't remember that instance if you had a phone?
I had a phone, yes. I don't know if I had it in my hands or,
Was the phone still in working order or was it smashed?
oh, it was smashed in all
Okay, so you
pieces.
didn't have a working phone. That's,
Right,
you had the remnants of the phone.
yes, yes.
Okay. Your Honor, people have no further questions at this time.
Thank you. Any cross-examination?
Yes, Your Honor. Let's start with Miss Rendon. You stated when you took your oath to testify that your name is Christy Lee Rendon.
Mhm.
And that's your true legal name?
Yeah.
Is that the only name you've ever been known by?
No, I've been married several times.
Have you ever changed your middle name? Have you ever changed your first name? Okay.
Changed, you mean, what, like legally or?
Yes.
No.
Is there any reason that why, when the police came to speak to you, you would have told them that you were Christina Alexandra Villa?
Christina Alexandra Villa?
Yes, is there any reason you would have given the police that name?
I don't think so.
Because that's not your true legal name.
No, it's not my name. I could have told them Mickey Mouse for all I know. Everything was crazy. And I did have last name, yes, so.
I'm sorry, I didn't quite hear that. Could that be repeated?
I said, and I did have last name. Villa, so.
Was that a prior married name? When's the last time you were legally known as Christy Villa?
It's been a long
More than 10 years?
time.
Is that a yes?
Yes.
More than 15?
I don't think so.
Okay. So we're talking about some events that happened over a several day period.
Mhm.
You stated
Yes.
Months,
Pam, is that a yes?
yes.
Okay, just,
And so you stated that Mr. Jackson was in your apartment. Okay. And stated at one point you left to go to your cousin's. You spent the night at your cousin's. Did Mr. Jackson come to your cousin's house?
No.
Did he contact you while you were at your cousin's house?
Oh, yeah.
Okay. But he didn't come to your cousin's house. He didn't try to get you back to your apartment. And you were able to go to your cousin's house that night?
It was a different night. That night I went to the hotel where the care program for 30 days.
So, but the night that you went to your cousin's house, you were able to go there without any problem?
Yeah. Well, actually, yeah.
Okay. And at that point, had some of the conduct you've been testifying to, had that been going on prior to you going to your cousin's house?
It's for months.
Did you call the police at that time?
No, I don't think so. My uncle came and got me, and then he took me to my cousin's while he was running around talking about getting.
So you didn't call, so you didn't call the police?
Before you go further, if the record reflect when she said he was running around, she pointed at the defendant. Just to make clear that she wasn't talking about the uncle.
so we'll clear it up with the, I'll allow you to rephrase the question. Okay.
So you were at your cousin's house.
Is that a yes? Okay, thank you.
Assault, so other types of conduct, it was your testimony that that stuff was going on prior to you going to your cousin's house,
Yes.
and you did not call the police while you were at your cousin's house.
No, I did not.
And your cousin's house was a place you felt safe,
Yes.
and Mr. Jackson didn't know where that was,
Correct.
so he couldn't have found you there.
Right.
Okay. Then at some point, he lets you leave the apartment and you go to a party store.
When he would leave, I would leave. If so that I wasn't there when he got back.
Okay.
So, yeah, that.
Was he there when you left to go to the party store?
Yes.
And you left to go to the party store without any issue?
Actually, honestly, I don't remember if he was there or not, but there was no issue when I left. He wasn't there. He wasn't.
Okay, so just so we're clear.
Yes.
Was he there when you went to the party store?
No. When I got back, he was in the party.
Okay, and he didn't have anything in his hands. That was your testimony, correct?
No, I don't think so. No.
Your Honor, I believe that actually was not her testimony. She said she didn't remember.
All right, if she's able to indicate what she thought for the record, So the objection,
I don't
if there was an
remember
objection,
anything. I
it's,
don't know what we're getting at here with anything in his hands. I'm not really sure what.
all right, ma'am, all I'm gonna have you do is answer his question,
Okay.
yes or no.
So
Okay.
in your memory, he had nothing in his hand.
Right. I mean.
And so he was outside your apartment at that point in time,
Yes,
and it's your testimony that he approached you,
yes.
and that at some point he put his hands on your neck?
Well, instantly, and then I ended up on the other side of the parking lot. so-
Okay. But that all occurred outside your apartment?
Yes, that is correct.
Okay. When you got to the party store,
Mhm.
Yes.
Yes,
the most recent incident that we're talking about that led up to the police and care coming and you spending the night at the hotel,
okay.
that had been going on for the day?
Weeks, months, just,
I'm talking this specific incident.
yeah,
Okay.
yes, yes.
So it'd been going on for a day or so?
Oh, more than that.
Okay. When you got to the party store, were there other people in the party store? Did you ask anybody to call 911 for you?
No,
Did you ask the
he
store?
wasn't there when I left to go to the party store.
But he had been assaulting.
Days prior, weeks prior, months
Yeah.
prior, yes.
So when you were at the party store, did you ask anybody to use a phone to call 911?
No, I did not.
Did you make any attempts to call 911 and report what had been happening?
Yes, and I got my phone smashed.
No. While you were at the party?
Oh, no, not at the party store.
Okay. So you're saying it's your testimony that you believe this couple of incidents that we're talking about today that led up to care coming and the police coming and you spending the night at the hotel. It's your belief that that actually happened in December?
No, I was at the hotel the whole month of December, because on Christmas, my dad picked me up and I went to my parents' house and I feel like it was late November, because I could only stay for 30 days, and I stayed 30.
So you believe it was late November,
It was sometime in November.
but you don't
I don't know the day, no,
actually remember specific days or?
No. no.
So over this period of time you've been testifying to, how many times do you think you've called the police?
I tried maybe 3 times, but never spoke to them. Like on the phone to have them come out. Actually, there was one time he did come out, he ran, that's right.
When,
Kevin.
do you know when that was?
I did not, no, I do not.
Okay. But you would agree during this weeks and months period you're testifying about, there were plenty of times that Mr. Jackson was not at your apartment,
Yeah, there was plenty of things.
or that you were somewhere where Mr. Jackson was not.
Yes,
And those would have been opportunities you could have found a time to go to the police station, call the police, report what was happening.
yes,
And during those periods of time, you never did.
that is correct.
All right. I have no further questions.
Redirect?
Yes, Your Honor. Why not?
Well, fear, period,
Fear of what?
of being hit, hurt, choked, kicked, beat, whatever, anything.
So you feared that you were going to be beat by Mr. Jackson if you called
Yes.
police?
Yes, he told me.
But so why did you try calling police while he was there with you?
Why did I?
Yes. What made it different?
Because I wanted him to just get away from me, leave me alone and just pretend I didn't even exist. I mean, I practically begged him to do that, but he would not do it.
Now,
I didn't want to get, I didn't want to cause him any legal problems. I just wanted him to go away. And I mean, I took a lot of beatings for that.
now, there's been talk about you going to spend the night at your cousin's. You said that you were being beaten for months.
I don't know.
Do you remember when you went to your cousin's house? So you don't remember if it was during this time period that we're talking about or before?
Actually, it was the day before the actual police, before the whole incident happened. Because things were getting out of control and I was, worried and scared. And so I left and then I came home. It's nothing. And then the very next day was when I went to the care program.
You said on cross-examination that as soon as you came back from the party store, Mr. Jackson's hands were immediately on your neck, and then you ended up on the other side of the parking lot.
Yes.
Can you please explain a little bit more about that? Of how you ended up over there?
Well, he dragged me, he choked me, and I kind of, I must have was unconscious for a hot minute or something. And then I was on the other side of the parking lot. That's when my phone got destroyed, and then all these people were there. And next thing you know, they're calling the police. And
Now, briefly, you just said that that's when your phone was destroyed, but did he testify the phone was destroyed inside a couple days prior?
yeah, and that was not the first one.
Now, can you please describe the location that you're gaining consciousness in on the other side of the parking lot? Is it just in an open
So
space?
the parking lot is right off MLK. There's, a bus stop there. So it started there and then probably 15, 20 feet.
But are you just in the open? Are you next to a building?
There's 2 apartment buildings there. So the parking lot is square, and they're small apartments. There's only 1, 2, 3, maybe 6 in each one. So,
And when you were gaining consciousness, you were closer to your apartment?
yes.
Thank you. The other people, no further questions at this time.
May this witness be excused?
May, Your Honor.
Any objection to the witness being excused?
No, Your Honor.
Okay, ma'am, you're excused. Thank you.
Thank you.
Next witness.
Your Honor, the people call Officer Rachel Logsdon.
Officer Logsdon, I'll have you come right in front of here and I'll swear you in. Officer Logsdon, do you solemnly swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth under the penalty of perjury?
I do.
Can you please state your name for the record
Rachel Logsdon,
and spell your last name?
Logsdon.
Right, I just do that for the court reporter. You may have a seat here. Mr. Pfeiffer, when you're ready.
Yes, Your Honor. Good morning, Ms. Logsdon.
Morning.
Where are you currently employed?
Lansing Police Department,
And what is your role there?
police officer,
And how long have you had that position?
19 years.
19 years. So is it safe to say that you were working in that capacity on November 15th, 2021?
Yes.
And on that date, did you respond out to 4612 South King Street?
Yes.
And did you make contact with a Christina Rendon?
Yes.
Is that the name that she gave that day?
No,
What name did she give?
Christina Villa,
And you describe her a little bit?
white female, possibly in her 40s, blonde hair.
And why did you go out there that day?
We received several phone calls about a male assaulting a female in the parking lot there, at the apartments.
And when you came up and saw this female like you just described, what was her demeanor? How did she appear?
She approached me and she was extremely upset, crying, shaking.
Did you notice any injuries on her?
She did. Her neck was very red around the base of the neck and around the sides.
And do you observe any other injuries, any bruises
At that time, no.
later that day?
Yes.
And can you describe those a little bit, please?
She had bruises on her legs and her thighs.
Now, did you speak with this woman?
Yes,
And with other individuals there at the scene?
briefly, yes.
After speaking with her and investigating this matter, did you determine that a domestic assault had occurred?
Yes,
Did you determine that she had been the victim?
yes,
Did you determine that it occurred recently?
yes.
And based on the injuries that you observed personally, did those seem to match with what you had been told?
Yes.
Who did Miss Villa say had attacked her?
Kevin Jackson.
Did she say what her relationship with him was?
She said they were boyfriend girlfriend.
Did she tell you if it had been a momentary incident or a prolonged event?
Objection, Your Honor, at this point. We'll start objecting hearsay.
Your Honor,
Response?
Your Honor, this hearsay is admissible under MCL 768.27C, since a victim of domestic violence explaining the infliction or threat of infliction of physical injury upon herself that is close in time to when she's speaking with the police officer, and there is corroborating facts that were independently observed by the officer.
Response?
Your Honor, I would simply just ask the court to withhold ruling on the admissibility of any of this testimony until the conclusion, to make sure that that all of the elements of 27C are actually laid. Specifically, 27C requires that the statement be given in such a manner as to make it trustworthy. In this case, I think it's clear from the testimony that the court's already heard that Ms. Villa does not at all at this time, and may not have at that time, had a very clear memory or recollection of what went on, or the timeline of events of how this proceeded. And with regards to several of the counts that are charged against Mr. Jackson, the timeline of when these things occurred is essential to the prosecutor being able to ultimately make their case.
Mr. Fine, for any response?
Yes, Your Honor. There was corroborating factors to establish that there was trustworthiness of the statements to the officer at that day. Again, it's not trustworthiness now. In fact, she testified to the fact that because of all of this, today, she had difficulty remembering certain aspects. There was nothing to indicate she had not remembered those aspects that day, and they were independently corroborated by the officer. Further, as to the timeliness aspect, the fact that she was held against her will for several days extends the timeline duration for 27C. Because if someone is attacked on day 1, held against their will for 7 days, and finally speaks to police on day 8, they are still able to tell the police under MCL 768.27C about the attack that happened on day 1. Because the timeliness is extended by the defendant's conduct. Does not have to immediately happen.
So I find that the statute has been met for purposes of trustworthiness at the time the statements were given to the officer. So I'll allow the hearsay testimony pursuant to the statute to come in for preliminary examination purposes only, my understanding. So the objection is overruled and you may proceed.
Thank you, Your Honor. So, did Christina tell you if this was an immediate event or an extended event?
An extended.
Now, I'd like to take that day's events that she told you about and then work backwards if that's all right. So what did she tell you happened on that day, the 15th, that you came out there?
Sorry, do you want me to start with from the original event or just what occurred on the actual?
When she returned to the parking lot.
Okay.
That residence on the 15th.
She said that she went to the party store to grab some things and she returned to the parking lot. He was waiting outside the door of the apartment for her. He was agitated and upset with her because he felt that she had been gone too long and he wanted to know what she had been doing.
Did she say if he had anything in his hands at the time?
Yes, she did.
And what did she say that he had in his hands?
She said he had a knife.
Did she say what he did with the knife?
She said that he threw it at her when she attempted to run away.
So she said she tried to get away.
Correct.
And what did she say happened next?
He chased her down, grabbed a hold of her by the throat, and then drug her back to the side of the apartment building and held her up against the apartment building by her throat.
Did she say she had a dog with her at the time?
Yes, her service dog.
And can you tell us a little bit more about what she told you about that?
She stated that when he was holding her up against the building, that he had knocked the service dog out of her hand to the ground, stating that he was going to kill it.
Now, did you find Mr. Jackson at the scene?
I did not.
Did you search for him?
Yes,
And you're unsuccessful.
correct.
And what time of day was this, roughly?
I believe it was 12:30 in the afternoon.
So middle of the day?
Correct.
And there were other individuals there who
Yes.
witnessed it?
Correct.
Now I'd like to go back a little further. How did she say that this all started?
She told me that the prior Tuesday, that they had had an argument and that there was an assault that had occurred on that day.
Now, Your Honor, before going further, I'd like to take judicial note, the court to take judicial notice of the fact that November 15th, 2021, when she spoke with the victim, is a Monday, and I think prior Tuesday would be November 9th, 2021.
Any objection to the judicial notice that Tuesday, 2021 was November 9th?
No.
Thank you. You may proceed.
Now, she said that he had assaulted her on that day.
Yes,
Did she say where that happened?
at the apartment.
And what else did she tell you about that?
She stated to me that in the course of the assault that she had her phone. She attempted to call 911 and that he took the phone from her and threw it on the ground, breaking.
And did she say if he continued to assault her?
Yes.
Did she give you any details about those assaults?
And she stated that on occasion, I don't know if it was that day on that Tuesday or in the week following, but that over the course of that time, he had assaulted her with numerous objects throughout the house, and broomsticks, electrical cords.
Thank you. Did she say if she tried to leave?
She said that she was unable to leave, and because when she attempted to go to the door, he would block the door from not allowing her to escape.
Did she say if this is the only incident with Mr. Jackson?
No, she advised me that since the beginning of the relationship, there had been several.
Objection, Your Honor, relevance. We're here today about what happened between November 9th and November 15th of 2021.
Response?
MCL 768.27B allows for evidence of other acts of domestic violence.
MCL 76827B requires the prosecution to provide the defense prior notice of the assaults, who the witnesses would be, and the nature of the testimony that would be elicited. No formal notice has been given. I would object to 27B evidence being presented at this hearing.
Your Honor, that's actually incorrect. No notice requirement is in 27B or 27C. Disclosure requirement 15 days prior. Additionally, the 15 days prior is a trial right. This is not a trial. The disclosure requirement and the timeliness of it does not apply for the evidentiary hearing that is a preliminary examination, only for the trial. Additionally, the evidence is in the police report that was provided to defense more than 15 days ago, and the people's burdens, even for a trial, have been met.
I'll allow it for preliminary examination purposes only. It's not, I'm looking at these counts in relation to the dates that have been given. So
Just-
you're really, but what you're indicating is you don't want the character evidence to come in.
Well, and just to make the record clear, the fact that it is admissible under 27B doesn't make it relevant to this proceeding. It might be relevant at trial, but the fact that this would be done was not provided notice. I would object to the prosecutor conducting the business in this way.
All right, I'll overrule the objection and allow the prosecutor to continue in the hearsay testimony concerning the victim in the matter, with the understanding that I really look at this as character evidence more than I look at it in regards to the actual dates in question.
Thank you. So could you please repeat your answer to that?
She stated there had been prior assaults in the past.
She said at some point she had to replace her doors.
Correct, that he had broken into her apartment, and that she had to contact management to get a new door and a new door frame.
Did she say if he lived there?
She said that he stayed there on and off, but that he did not have a key to the apartment.
Did she say if she'd been trying to get him to leave?
Yes.
Did she say how she finally left?
She said that he gave her permission to leave.
Give her permission to leave.
Correct.
Did he dictate where to go?
To the store across the street.
And as the party store that she went to?
Correct.
Or at least the time that she left?
Yes.
To be clear, she indicated to you that she did not feel she was free to leave her apartment over this time period.
That's correct.
Thank you. Your Honor, at this time, people have no further questions for this witness.
Any cross-examination?
Yes, Your Honor. So just to be clear, when you responded and asked the complaining witness for a name, she gave you the name Christina Alexandra Villa, correct?
Yes.
And that's what you put in the police report?
Correct.
Okay. All right. So start with, she testified that she had to replace several doors. Correct?
One door.
One door. Did she tell you when she had to replace that door?
No.
Did she tell you that she actually saw Kevin Jackson break that door?
No.
So she assumes that Kevin Jackson broke that door,
Correct.
but she does not actually, she didn't give you the impression she actually knew it was him.
She did give me the impression that she knew it was him, but she did not see him do it.
She didn't see him do it.
Correct.
Okay. And you didn't respond the day that that would have happened?
I did not.
So you have no actual personal knowledge that that actually ever occurred?
No.
So what you responded to was allegations that she was making for incidents that happened between November the 9th of 2021 and November 15th, 2021, correct?
Yes.
And specifically on November 15th, 2021, she told you that that morning, he allowed her to go to the party store, correct?
Yes.
So she led, So it was her statement that he was there when she left to go to the party store.
Correct.
And then when she came back, he was standing outside of the apartment.
Correct.
And he was, the argument according to well, she told you she was Miss Dia, but actually Miss Rendon was that over how long she had been at the party store.
Yes.
And that is when she told you that he grabbed her by the neck.
Correct.
And that occurred outside of her apartment.
Yes.
And what occurred inside her apartment was assault with his hands and a broomstick.
Prior to that day. Yes.
Okay. Did she ever tell you that during this week period of time, she was able to leave or she left to go to anybody else's house?
No.
Now, you testified that she told you that that her phone had been broken at some point during this, correct?
Yes.
Did she ever tell you she came into possession of another phone? No. Did she in fact tell you that because that one phone that she had was broken, she had to order a new phone?
Yes.
And she was waiting for that phone to arrive?
Yes.
And so her statement to you was on November the 15th, she at no point had a working phone.
Right.
And she claimed that she told you that he had a knife in his hand and he threw it at her. That was your testimony?
Yes.
And was it before that or after that that he put his hands around her neck, according to Ms. Rendon?
Yeah.
Okay. And after that occurred, Ms. Rendon told you that he got into a car and we left?
Yes.
Did you search the parking lot to attempt to locate a knife?
No.
Did you ever locate a knife?
No.
Why didn't you search the parking lot looking for the knife?
I spent nearly 2 hours with the victim at the time of the call. So by the time that I had to leave the scene, it was with her to get her to a safe place. So I did not have the time to search for a knife.
Did you ask any other officer to come and search for a knife?
I didn't.
Would you agree that if a knife actually was thrown at her, that it would be important to collect the evidence of that assault if you could?
Yes.
And you chose not to take care of that?
I didn't choose not to. Actually, it was not a thought in my mind at the time. I was trying to get her someplace safe.
So but you could have had another officer respond and search for the knife?
Yes.
I have no further questions.
Redirect.
Yes, Your Honor. Now, multiple times during cross-examination, Mr. Nichols referred to the individual he spoke with as Christina Villa and then Christina Rendon. A question for you. When you were entering into this courtroom, did you see a male and a female individual leaving it shortly before?
Yes.
Did you recognize the female?
Yes.
And was that the individual you spoke to that day?
Yes.
Thank you. This time, people have no further questions.
May this witness be excused?
She may.
Without objection, the witness is excused. Mr. Pfeiffer, any further witnesses?
I'd just like to quickly judicial notice of the fact that the individuals who left before the officer appeared to testify involved a male and the victim, Christina Rendon.
So with that understanding, any objection to that?
I don't see how it's necessary for the court to take judicial notice of who left the courtroom. The officer just testified she saw a man and a woman leaving the courtroom and that the woman was who she talked with that day. I think that testimony is sufficient.
All right. Any other proofs, Mr. Pfeiffer?
No, Your Honor, I just want to be abundantly cautious on that front.
Mr. Nichol, any proofs today?
No proofs from the defense today.
Okay, motion for bind over.
Your Honor, people believe that a probable cause burden has been met for each of these counts. However, people are requesting that there are modifications. Count 1, 2, 4, 5, and 6, that the victim name be changed from Christina Villa to Christina Rendon. Specify that as her current legal name.
Okay, so as to counts 1, 2, 4, and 5, and 6, the name on an amended complaint is requested for Christina Rendon, as opposed to Christina Villa.
Yes, and we'll make the changes to any felony information in regards to the complaining victim and the witness list. But as far as the actual counts being asked to be bound over, those changes are requested. The other requested change is for count 6, assault with a dangerous weapon, felonious assault. We would ask that the date range be extended to November 15th, and that the dangerous weapon to it to be a broomstick or a knife.
Anything else regarding motion for bind over?
Your Honor, as to a brief argument, the victim testified to the fact that the defendant beat her inside of her home, which would be domestic violence, third offense, a felony. Then she tried calling 911. He got the phone out of her hand and destroyed it. That is interference with electronic communications, count 7. And that is count 3, interfering with a crime report by committing a crime or threatening to kill or injure an individual. And actually, I'd ask that that date range be extended to the 14th as well, because we also heard testimony that she tried to leave specifically to get help, and the defendant stopped her. Given the fact this happened over numerous days, I believe an amended date range of count 3 of 11/9/21 to be arranged between 11/9 and 11/15/21 is appropriate. And it also goes to count 1, unlawful imprisonment. She tried to leave. He physically got in her way to stop her in order to facilitate the commission of domestic violence third offense, in order to facilitate his escape and getting away with committing that felony. The escape doesn't need to happen immediately because Mr. Jackson's thinking long-term. The second unlawful imprisonment is on 11/15/2021. We heard testimony from the officer that the victim told Officer Logsdon he was angry with her. She ran away, threw a knife after her, chased her down, grabbed her by her throat, and in order to strangle her, dragged her across to the parking lot to put her up against a wall. Unlawful imprisonment does not need to happen for an extended period of time. It can be for even a moment. She tried to get away. He physically stopped her in order to facilitate the commission of a felony. That felony being assault with intent to do great bodily harm, less than murder, or by strangulation. And as a result, we have 2 separate unlawful imprisonments. First count, from stopping her from leaving her own apartment between the dates of 11/9 and 11/14, in order to facilitate his assault of her and also facilitate his escape for assaulting her. Then we have a separate unlawful imprisonment in the parking lot on 11/15, the day that the police went out there. Because she tried to get away. He chased her down, stopped her, dragged her across the parking lot, held her against a wall in order to facilitate his strangulation of her. Additionally, we heard the fact that she lost consciousness, which is one of the required elements for count 4, assault with intent to do great bodily harm, less than murder, or by strangulation, an impact on the victim's ability to breathe or consciousness. And then for count 6, assault with a dangerous weapon, felonious assault, we heard he threw the knife at her. Thankfully missed. But also that he beat her with a broomstick to the point where she had bruises on her legs, which is independently verified by the officer. I'd ask that you bind over on those 7 counts with the minor changes that have been requested. Thank you.
Response?
Yes, Your Honor. As to the unlawful imprisonment counts, Well, that confinement or that imprisonment doesn't have to be for any period of time. It is required that it be that the person either be restrained by means of a weapon or dangerous instrument, secretly confined, or restrained to facilitate the commission of another felony or to facilitate flight after the commission of the felony. As to the unlawful imprisonment, the prosecutor is attempting to add connected to the incidents of domestic violence. The testimony of Ms. Rendon was not clear that he was stopping her from leaving while the domestic violence was going on, during it, that domestic violence occurred immediately after he stopped her from going. And the testimony was not clear that he stopped her from leaving and then fled. Simply that at some point she might have tried to leave and he stopped her from leaving. Additionally, the prosecutor wants to speak to the fact that she was fleeing at certain times to go get help. I think that her credibility, if that is what she would attempt to testify to, her credibility in that would be incredibly suspect, considering the fact that she testified today that there were 2 separate times where she left the apartment completely, where Mr. Jackson was not with her. And during those entire periods of time, she did not make one single attempt to get help. She didn't call 911. She didn't ask anybody else to call 911. She didn't tell anybody else what was going on. And so I find it, like I said, I find her credibility on that incident lacking. But specifically to count 2, the unlawful imprisonment, the prosecution is attempting to attach to the assault with intent to do great bodily harm or assault by strangulation. That happened in broad daylight, according to Ms. Rendon's testimony, if the court accepts it. That happened in broad daylight. Well, at least 2 other people were watching it occur. And the only restraint that she testified to occurring is the restraint that would have been necessary specifically to complete the strangulation. And not to facilitate his flight. He completed this, by her testimony and the officer's testimony, the assault with intent to commit strangulation began immediately when she entered the parking lot. I don't believe her testimony was that he chased her down. It was simply that she was trying to get away at that point. It's just he walked up to her, he was mad, he grabbed her by the neck, and that was immediate. And that he dragged her and she lost consciousness. The curious thing about that is she testified specifically that she remembers being dragged, but also testified that she passed out and doesn't remember what happened. And so I think there's a lot of times during this incident, during this testimony, where her credibility is suspect. And so I would ask the court not to bind over on either unlawful imprisonment count. I don't think the testimony is clear enough to even meet a probable cause standard that any incident of domestic violence or any unlawful imprisonment was done to stop her or to assist him from fleeing, because the testimony is domestic violence. Again, there was no testimony that he stopped her from leaving and then left himself. There's no clear testimony that he stopped her from leaving and then assaulted her. And so for standing in her way, there could be a ton of different reasons why that may or may not have occurred. As to the unlawful imprisonment tied to GBH, again, this happened in broad daylight. That the only restraint was the restraint merely necessary to commit the assault with intent to do great bodily harm. No more was done. And while it does say that the restraint doesn't need to be for a particular length of time and may be related to or incidental to the commission of another crime, that restraint was not incidental to the commission of the alleged assault by strangulation. It was essential and one of the primary elements of that crime. Without that restraint, he did not commit a GBH. And so essentially, the prosecutor is asking the court to charge Mr. Jackson with two separate crimes related to one criminal act. And I do not believe that's what the unlawful imprisonment is meant to do. While it can be incidental, there has, by my reading of the jury instruction of the statute, there needs to be more restraint than necessary to commit the underlying crime. As to interfering with a crime report, she did say that she picked up her phone. She said that it was her plan to call 911, but there was no testimony that Mr. Jackson was made aware of that. There's no testimony that Mr. Jackson's breaking of her phone was done with the intent to interfere with her ability to report a crime, or done with any more intent than necessary to destroy the phone. And so without some evidence that the purpose that Mr. Jackson was breaking that phone was to stop her from making a call to 911, I don't think there is sufficient probable cause to bind over on count 7, interfering with electronic communications, and therefore, without count 7, the people cannot meet their burden, even at a probable cause standard, for interfering with a crime report. With respect to the DV third, I would leave that to the discretion of the court as to whether or not the court believes the testimony here was sufficient and credible enough to allow bind over on a domestic violence third. As to felonious assault, I would object to the adding of a knife. When asked several times, there was no recollection or testimony from Miss Rendon that Mr. Jackson ever had a knife in his hand. And I would leave to the discretion of the court whether the court feels that a broomstick qualifies as a dangerous weapon. The dangerous weapon is any instrument that is used in a way likely to cause serious physical injury or death. Simply, all she testified to was that he hit her with it. She didn't testify specifically how many times. She didn't testify to where she hit him with it. She didn't testify whether the broomstick was metal or wood. She didn't testify whether it broke, how easily it would have broken. And so there is, in my estimation, not sufficient evidence on the record to establish probable cause that if the court believes that Mr. Jackson hit her with a broomstick, of course, we're not conceding that action actually occurred. There's not sufficient evidence to establish that if that was done, it was done with the intent or used in a way likely to cause serious physical injury or death. Simply, it sounds like it was used in a way that was likely to cause bruises, which would not qualify as serious physical injury or death.
Thank you, counsel.
Thank you.
Any response?
I'll keep as briefly as I can. First, whether an object is a dangerous weapon under the circumstance of the case is a question for the fact finder per People v. Norris, 236 Michigan Appeal 411 from 1999. And there is case law specifically applying to whether a broomstick is a dangerous weapon. People v. Knapp, KNAPP 34 Michigan App 325 from 1971. It's a question of fact for the jury, Your Honor. Personally, I believe that someone being beaten with a sturdy broomstick is able to cause dangerous harm, significant harm. As for the unlawful imprisonment, she testified she tried to get away. He got in her way and stopped her after he beat her. And then also that the beatings continued. And Miss Rendon was very honest with this court that she has trouble today remembering exactly what happened during these incidents because so many incidents happened at the hands of Mr. Jackson. Thankfully, we have the officer who spoke to her immediately on the 15th. And we heard the testimony of what she told the officer on that day. Your Honor, I would ask that you look at the evidence in its totality and bind over as requested. as I believe the people have met their burden for a probable cause standard to bind over on each of these counts. The unlawful imprisonment in furtherance of this, in order to commit the strangulation, certainly applies. She tried to get away. He chased her down and stopped her. Wasn't just standing there. He tried to get away. They physically restrained her. And then he dragged her across the parking lot, put her up against a wall. He unlawfully imprisoned her in order to facilitate the commission of assault by strangulation. As the bind over is requested.
All right, so the bind over motion is made on a probable cause standard. That's probable cause to believe that the crimes were committed. So it's the lowest standard, probable cause being the second lowest standard in criminal law. Highest standard, of course, being the standard for conviction, which is beyond a reasonable doubt. I will take this one count at a time since we have numerous counts and amendments. So as to count one, which is 11-9 to 11-14. The count reads to secretly confine and knowingly restrain Christina, and then we have the amendment Rendon, or knowingly restrain Christina Rendon to facilitate the commission of domestic violence. In the third offense, I believe there was probable cause testimony to indicate that there had been an ongoing domestic assault situation going on. And at times she indicated that he had blocked her off from leaving the residence. He did not allow her to leave. This was meant for purposes to keep her location secret at that time, or not allow her to facilitate a report or or flight from the domestic assault situation. I believe there's probable cause evidence to bind over on count one, unlawful imprisonment, concerning the domestic assault that has occurred from 11-9 to 11-14 on Christina Rendon. As to count two, on about 11-15-2021, it is less clear concerning the events on November 15th, because she was already at a party store and this happened in front of people, in front of individuals, which kind of knocks out some of the secret confinement indications here. And so this would be linked to the strangulation that was involved in the count and to facilitate that. And I don't think there's evidence to indicate that this facilitated. If you're going for count one, I believe that we'll get to that count, but I don't believe in November 15th that there's probable cause evidence to believe that the unlawful imprisonment, and what kills us is the secret confinement that happened in front of people, and the fact that she'd already left the area and come back. So did knowingly restrain Christina Rendon to facilitate commission of assault by strangulation, and that's a facilitation. I will not bind over on count two, the unlawful imprisonment, which is November 15th, 2021. Counsel?
Just to be clear, you're not applying the secret confinement to the facilitation of the assault by strangulation.
I'm applying both right now.
Okay, just to make sure that they're separate.
I'm not applying. Once we get to that count, I'll deal with it. I don't believe that based on the testimony that the count two has been facilitated by the strangulation or secret confinement either. Three things are met under that statute. It's an A, B, and C. Under a person restrained by means of weapons or dangerous instrument. Restrained person was secretly confined, which means to keep the confinement or location of the restrained person a secret. That one's tough. The person was restrained to facilitate the commission of another felony or to facilitate flight after the commission of another felony. I understand the argument. I just don't buy it in front of other people.
I misheard. That's why I want to make sure I was understanding correctly.
So all three. So I do not bind over on count two. Count three, as to 11-9-2021, there was sufficient testimony to indicate that the phone was broken in relation to reporting out. So did through the unlawful use of force prevent or attempt to prevent another person from reporting a crime committed or attempted by another person, and violation involved in committing or attempting to commit interference with electronic communications. I'm going to indicate for the record that this would be 11-9 to 11-14 of 2021, not on the 11-15 date. But during that time period, the victim did testify, I should say, Ms. Rendon testified that the phone was damaged, and then she indicated for the purpose that she could not call out. which meets the reporting aspect of that crime. As to count 4, I do find that on November 15th, 2021, the defendant did, by a probable cause standard, did make an assault upon Christina Rendon by strangulation or suffocation. I think that was the strongest testimony that this court heard in regards to the parking lot of the Martin Luther King address, which is 4620 South Martin Luther King on November 15th. I find there's probable cause evidence to believe that the count 4 is bound over. Count 5 as to November 14th is the misdemeanor count, but it's aggregated to a felony because of the offense notice. So I do find that did make an assault and or assault and battery upon Christina Villa. It'll be Christina Rendon upon an individual with whom he had a dating relationship. I do find that from November 9th to November 14th, that there is sufficient probable cause evidence to believe that an assault and battery did occur on that date. I think Ms. Villa testified to that in regards to the assaulted behavior. And so I do believe that misdemeanor, along with the third offense notice 5-year, is bound over. Count 6 is a problem for me. Between November 9th and November 14th, did make an assault upon Christina Rendon with a dangerous weapon, a broomstick. There is testimony that there was a broomstick. She indicated I was assaulted with a broomstick. I heard no further details concerning that. Later, I heard that there were bruises, but I don't think those bruises, at least in my judgment, were linked to the broomstick. The knife I'm disregarding because she said that she indicated he threw a knife at me. No knife was found. No knife was. I just believe on a probable cause standard, there's not sufficient evidence to bind over from November 9th to November 14th. It would be November 9th to November 15th, since the knife would include behavior on the 15th. I'm not binding over on a probable cause standard. Count 6, count 7, I am binding over as sufficient to count 3. Did willfully and maliciously prevent, obstruct, or delay by any means the sending, conveyance, or delivery of an authorized communication. Count 7, I am binding over. In regards to November 9th to November 15th, there was plenty of testimony from Ms. Rendon indicating the phone was broken specifically to prevent or obstruct or delay any type of sending or delivery of authorized communication. So I will bind over on counts 1, 3, 4, 5, and 7. Counts 2 and count 6 for purposes of the preliminary examination are not bound over, and therefore will not be bound over and dismissed. 2 and 6. So 1, 3, 4, 5, 7 with the amended name and the amended dates as requested. Anything else from the people?
Not from the people, Your Honor.
Anything else, Mr. Nichol?
Nothing further at this time.
All right. So that's all for the record. I'll let them sign it and then I'll sign the bind over. Okay. And I'll just put the date on, so I don't forget. That's all for the record in this file.
Thank you, Your Honor.
Sir, will you identify yourself for the record on the Zoom?
My name is Jerry Robinson.
Jerry Robinson. Okay. And sir, you have a case in front of this court this morning?
Yes, I do.
What time is your case scheduled for?
It's a different judge.
11:15.
Say it again, sir.
11:15.
11:15, Jerry Robinson, is it?
Yes.
All right, I think you're in the wrong courtroom, but I'm gonna make sure, I'm gonna see if I can find out what courtroom you should be in, all right, sir?
Well, it's in front of Florentine.
In front of which judge?
Florentine.
Say it again, sir.
Tony Florence.
That's me, but I don't have an 11:15 on my docket.
What's his first name?
Jerry Robinson.
Jerry. I'm searching the court.
David Brasher versus me.
David Bushy LLC versus Robinson.
Pre-trial is for
Yeah,
10/5/22.
you're 2 months early, sir.
Sir, it's for October 5th. Your case, is that David, is it a civil case? David Bashir versus Jerry Robinson?
It is 10/5/2020.
Yeah, so October 5th.
Oh, I'm a month early.
You're almost 2 months early, I think.
2 months to the day.
Yes, sir.
I apologize for that, Your Honor.
No, you're good. I'm glad you found it. So come back to this courtroom on October 5th, all right, sir?
Yes, ma'am. Yes, sir.
All right, thank you.
January, February, March, April, May, June, July, August. 6, 7, 8. Eight months? Oh. Yes.
We're on the record in docket 22-01920. That's people, the state of Michigan versus Darnell Plummer. Will the parties please introduce themselves for the record?
Yes. Good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigl, so on behalf of Mr. Plummer, who's standing to my right.
And sir, you are Darnell Plummer?
Correct, Your Honor.
All right. This is the time set for a preliminary examination. Mr. Pfeiffer, how are we proceeding today?
Your Honor, I believe both sides will be requesting an adjournment today. The reasons for the people is that it was discovered yesterday afternoon that the defendant has been contacting the victim from jail. I have 14 calls from the Mason County Jail to the victim's phone number. I have 40 plus calls from Lansing Lockup, and then I have 6 video visits to the victim in the victim's name, all from the defendant's account. And if the court needs, I can approach with records of both. I have already provided those to defense yesterday.
Mr. Feigelson, so this is somewhat a discovery request because you anticipate new charges coming?
Potentially, Your Honor.
Right. So any comment on Mr. Pfeiffer's indication that this would be a request for adjournment on both sides?
Your Honor, a couple of things. We were in an attempt to try to work this matter out, short of adjourning it out, but Mr. Plummer had some disagreements with me and wishes to seek new counsel, Your Honor. So that's one of the reasons for the adjournment. I advised him of what those steps that he needs to take, either to write a letter to my boss and let Mr. Watson make that decision, or we would be free to, but he does usually get one attorney through our office or to retain his own lawyer. So we'd like some time for Mr. Plummer to do that.
And for the record, Your Honor, it's not just the possibility of new charges, it's the possibility of the use of forfeiture by wrongdoing as far as going forward with the preliminary examination.
All right, Mr. Feigelson, at this time, can I inquire of your client, just to indicate that he understands what's going on?
Yes,
today?
Your Honor.
So, sir, you understand that you have the right to a preliminary examination within 21 days.
Yes, Your
That's a probable cause hearing. It's my understanding we're adjourning it. Both sides are requesting adjournment. One is the prosecutor who may file additional charges. Two is that you may be seeking to retain counsel as opposed to have counsel from public defender's office. Is that correct?
No, I just wanted a new attorney.
So you
just don't have the funds, I'm sorry.
All right, so you would be going to the public defender's office, but seeking a different lawyer?
Right, now usually our policy is you get one lawyer.
All right.
I mean, he's free to write my boss, but that's been
Right.
Mr. Watson's policy.
But you indicate you understand the policy is that you get a public defender assigned to you and you don't get to pick and choose, but you're more than welcome to write a letter to the public defender who's in interim public defender right now,
Yeah.
Keith Watson, Mr. Watson, in order to indicate that you would like a different public defender. Do you understand that?
Yes, sir. Yes, sir.
Right. So I find good cause to adjourn. I'm not going to seek for a waiver of a 21-day right or anything. This is good cause to adjourn, since you're seeking additional counsel in this matter. And I don't want you to waive any rights without a lawyer present. And Mr. Feigelson's here, but if you're seeking new counsel, we can do that. But we'll probably set it on for the quickest preliminary examination date that we have. So this was initially set for today. I find good cause for the adjournment. Let's go 2 weeks just to be safe.
That's appreciated, Your Honor. It
Yeah.
will take time for my detective to go through the calls and the videos, as there's over 3 hours.
Okay. 2-week adjournment,
August 18th at 9:30, please.
August 18th at 9:30 will be the new date.
The people will be prepared by then. And I will say for the record that if witness interference is found, my intention is not to file a new case, but to present that evidence at the examination and add those charges to this case.
All right, so you're on notice, there may be new charges pending, okay?
Yes, sir.
So we are adjourning this to August 18th at 9:30, all right? Mr. Feigelson, still attorney of record. You're seeking to have different counsel. Either way, a public defender may be here on that date, I'm assuming.
It'll be me unless he retains somebody else. I don't think Mr. Watson's gonna, but I'll let Mr. Watson speak for that.
All right, that's fair enough, Mr. Feigelson. So we'll see you back here on August 18th. So I'll see you back here on August 18th at 9:30, okay, sir?
Yes, sir.
All right, thank you.
Thank you.
That's all for the record in this file. That is 22-01920.
The court could just reiterate not to call the victim or accept any video visits from the
And
victim.
any more calls is going to end up in additional charges.
Yes, sir.
So in order to prevent that, don't make any more calls.
Yes, sir.
All right, thank you.
Thank you.
Thank you, Your Honor.
Mr. Plummer.
Thank you, man. Appreciate it.
Dash 01810, people of the state of Michigan versus Tyrese Jones. Will the parties please introduce themselves for the record?
Yes, do that. Morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson, appearing on behalf of Mr. Jones this morning, Your Honor.
Sir, you are Tyrese Jones?
Yes, sir.
All right, thank you. This is the time set for a preliminary examination in this matter Mr. Pfeiffer, how are we proceeding?
Your Honor, an offer has been made to the defendant. It is my understanding the defendant is rejecting that offer. People prepare to proceed today. But first, we'd like to put the offer on the record and have that rejection be done on the record.
All right, you may proceed.
Your Honor, this defendant is charged with 2 10-year felonies, one of which is a discretionary consecutive felony, meaning it can be served back to back with the other ones, a 5-year felony, and then a 93-day misdemeanor. The offer from the people is for the defendant to plead guilty to aggravated domestic violence, which is a 1-year misdemeanor, and the people would kill agree to sentencing under 769 4A if eligible, meaning that if he successfully completes the domestic violence probation, that is effectively wiped from his record. It is my understanding the defense does not wish to take that offer.
Mr. Feigelson.
Your Honor, that is an accurate statement of the offer that was conveyed to me, that I conveyed to Mr. Jones this morning. And I believe Mr. Jones wishes to reject that this morning. But I'll let him answer that in a second.
All right, Mr. Jones, you understand the offer that's been made?
Yes, sir.
And it's your indication to reject that offer and then go to prelim today.
Yes, sir.
All right. With that understanding, the offer is made, the rejection's on the record, and we will proceed to prelim. Mr. Pfeiffer, you may call your first witness.
So the only thing I'd ask, I don't think there's only one witness here, but I'd ask for a sequestering if there's more than one.
Okay, are there any other, Mr. Pfeiffer, are there any other witnesses on this case in the courtroom?
Not that I believe are in the courtroom. Is anyone here a Lauren Jones? Then no.
All right. With that understanding, if anybody additional comes in, we'll address it at that time.
Right.
So sequester, the motion and request is granted. Mr. Pfeiffer, you can call your first witness.
People call Officer Caitlin Miller.
I don't do. Nobody's making. What's that? All right, Ms. Miller, I'm going to have you come up here and be sworn. It's Officer Miller right here.
Yeah.
Please go ahead and state your name for the record for the court reporter.
Caitlin Miller.
Okay, and traditional spelling?
Kateelyn, Miller County.
Okay. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right, you can have a seat here. Speak up to the microphone, since it is it's just for recording. It's not for any type of auditory.
Okay.
Mr. Pfeiffer, you may proceed.
Morning, Ms. Miller.
Good morning.
Where are you currently employed?
The city of Lansing,
And what is your role there?
patrol police officer.
So, Officer Miller, how long have you been employed with the LPD?
About 3 years.
Were you working that capacity on June 7th of 2022?
Yes, I was.
And on that day, did you go out to 221 East Hillsdale?
Yes, I did.
And that was as your role as a police officer?
Correct.
And is that in Lansing? Is
Yes.
that in Ingham County?
Yes.
Now, have you been out to that location before?
Yes.
And previously, had you made contact with a Tyrese Jones?
Yes.
Would you be able to recognize him again if you saw him again?
Yes.
Do you see him in the courtroom today?
I do.
Could you please identify either where he is or something about his appearance that would differentiate him from the other people in the courtroom?
He's seated to my left with a red shirt on.
Thank you. Your Honor, if the record reflects, you've identified the defendant.
Any objection?
Your Honor, I will object, but I'll reserve the right to cross on.
All right. So for purposes of the preliminary testimony, the witness has been identified by the witness has identified the defendant.
Thank you. Now, previously, when you had gone out there and you had interacted with Tyrese Jones, did you also interact with a Lauren Jones?
So to clarify, I did not interact with Mr. Jones when I interacted with Miss Jones.
Correct.
So yes,
I mean,
previously,
in the
yes.
past,
Yeah.
not on 6/7, but previously when you interacted with Tyrese Jones, you'd also interacted with Lauren Jones.
No.
No,
No.
just Mr. Jones at that
Yes.
address.
Correct.
Okay. Now, on 6/7/2022, did you make contact with Lauren Jones?
Yes.
Did you talk with her?
Yes.
And roughly what time of day was this?
About 4 p.m.
Now, as a result of talking with her, did you determine that a domestic assault had taken place
Yes,
and that Ms. Jones was the victim of it?
yes,
You determined that it had happened recently?
yes.
Now, did you also observe damage to some of her property?
Yes.
And what was that property?
It was a laptop computer, a cell phone, and then an interior wall of the residence had some damage to it.
Your Honor, I apologize. I am going to need some exhibit stickers. Move so quickly into this. I simply forgot to have the court get them ahead of
So
time.
if you present which exhibits are, I'll have the judicial assistant mark them.
For the record, he has shown me.
Thank you, Mr. Feigelson. So that'll be marked as exhibits 1, 2, and 3, or A, B, and C.
1, 2, 3, and 4. I have them on the top right corner. Just let you know.
All right.
I do apologize.
No worries.
I certainly try and have them marked ahead of time. Will you personally observe that damage?
Yes,
Do I need to stop talking while that happens? I don't want to make life.
Yeah. Yes.
I will
the
be
answer is-
silent.
The nodding of the head would indicate a yes. You may retrieve the exhibits.
Thank you, Your Honor. My apologies to your court reporter.
When you're ready. All right, you may proceed.
Thank you. Now, Officer Miller, did you take photographs of the damage that you saw?
yes, I did.
Did you also take a photograph of Ms. Jones?
Yes,
Your Honor, I'd like to approach with what's marked as people's proposed exhibits 1, 2, 3, and 4.
You may.
Officer Miller, do you recognize these photographs?
yes,
Were these the ones that you took that day?
yes.
Could you please identify what is pictured in each photograph and state which number it is?
So exhibit 1 is a photo of Miss Jones. Do I need to show that? Okay, a photo of Miss Jones just as she was to photograph her person.
Was that an accurate reflection to how she looked that day?
Yes.
Thank
you. The second exhibit is a photo of her cell phone with the cracked screen. Third exhibit is a photo of the interior wall with kind of looks like a hockey stick indentation in the wall, so just damage on that. And then exhibit 4 is the smashed laptop that was found in the roadway when we arrived on scene.
Thank you. Now, were those photographs accurate representations of how each subject looked that day?
Yes.
Your Honor, at this time, the people would move to admit people proposed exhibits 1, 2, 3, and 4.
Counsel, you've seen them. Do you have any objections?
No, Your Honor, I have
Okay.
seen them.
For purpose of the prelim, exhibits 1, 2, 3, and 4 admitted into evidence.
And the people would seek to publish them to the court at this time.
You may.
Thanks. So those things that you personally observed, separate from speaking with her, did that seem to match what she told you happened?
Yes.
Your Honor, at this time, the people would move to proceed under MCL 76827C as all the elements have been met. This is a victim of domestic violence, of a physical assault that just occurred, speaking to a police officer acting in their official capacity about an incident of domestic violence that had recently occurred. And there are corroborating factors here to indicate trustworthiness.
Any objection to the motion to proceed with hearsay testimony under the statute?
None today, Your Honor.
All right. For purposes of preliminary examination, being familiar with the statute, I believe the elements and conditions have been met for the hearsay testimony to come in, and so I'll allow the testimony.
Now, who did Miss Jones tell you had assaulted her?
Tyrese Jones.
And did she say what her relationship with him was?
It was a dating relationship.
You know if they lived together?
Yes.
Did they have any children in common?
She indicated that she was currently pregnant with this child.
So what did Miss Jones tell you had happened with Tyrese Jones earlier that day?
That they had gotten into an argument about the volume of the television because she had a work meeting. Miss Jones stated that Tyrese, I'm sorry, began making a bunch of noise downstairs during her work meeting, so she was unable to do it. So she later decided to turn off the Wi-Fi, which upset him because he had clients over for his occupation. At that point, Mr. Jones was agitated, so he came upstairs into her office space, forcefully entered and took her computer from her, and stated that he was going to break it or something along those lines.
And what did he do with it?
He threw it outside into the road.
And that's where you found the laptop, in the road?
Yes.
So what did Lauren say she did next?
She called the police and then hung up the phone after that. At that point, she saw that her computer was outside. He came back inside, pushed her down onto the couch, took her cell phone from her and threw it at the wall.
And you observed the cell phone?
Yes.
Did she give an estimate as to how much the cell phone or laptop maybe were?
I can't recall without.
So do you believe looking at a copy of the report will help refresh your recollection as to that?
Yes.
Your Honor, if I could approach the officer with a
You
copy
may.
of the report. Now, Officer Miller, I don't want you to read aloud from this report. Just read it to yourself. And when you feel it's sufficiently refreshed your recollection, or it's just going to be incapable of doing so, let me know. And I'll come retrieve it. All set? Now, Officer Miller, did that successfully refresh your recollection?
Yes.
So, did Miss Jones tell you an estimate for how much the phone or the laptop will work?
Yes.
And what were those estimates?
It would have, between the two items, about $1,500.
So he took her cell phones out of her hands, correct?
Yes.
And then destroyed them.
Yes.
And they weren't operable anymore?
No.
Did Tyrese say anything to her after that?
Miss Jones stated that Tyrese stated if she calls the cops, he will come back and fuck her up, is what she stated to me.
And then did he leave the residence?
Yes.
How did Miss Jones seem when you were talking to her?
Upset.
Did she seem concerned about what Mr. Jones had said, that he would fuck her up if the police came?
Yes.
Specifically because the police were there?
Yes.
Did you try to locate Mr. Jones?
I was unable to based on the information that she provided.
And was that simply because he wasn't there?
Yes.
What information did she provide about Mr. Jones?
He stated that he likely went to an unknown female's house in Jackson. That was essentially all that she said about his location.
Did you provide any information about him as a person, his description?
Yes.
And what kind of description did you give?
She stated that he was a black male that had dreads. I believe I can't recall what she said in terms of like height and weight from my report.
But when she was describing him, did it match the individual you already know as Tyrese Jones?
My interaction with Mr. Jones in person was after this incident occurred.
So, today, did her description match what you know about Mr. Jones?
Yes.
But I'm gonna object. I don't know how she can say that from the event that occurred based on something she saw after the fact, right?
Response?
I'm asking if it matches today.
I think there's no indication that at the scene she could match the description, only that she matched it for today's purposes.
Correct.
Objections overruled.
And remind me, did Ms. Jones say if they lived together?
She did.
And you came out to this same address, 22 East Hillsdale, later, after this assault, correct?
Yes.
And you saw the defendant there,
Yes.
and you identified him as Tyrese Jones at that later date.
Yes.
Thank you. And if I may have one moment.
Certainly.
So to be clear, Ms. Jones didn't tell you that he had physically assaulted her this day, just that he threatened to do so, correct?
On the date of this incident,
6/7.
no, she stated he did physically assault her.
Okay. How did he physically assault her?
He pushed her.
Pushed her. Okay. Thank you. Did she tell you when in this sequence it happened?
Yes.
And when was that?
After throwing the laptop, he came back inside, pushed her, took her cell phone, and then threw it. So it was between the damaging of the laptop and then the cell phone.
Okay. And then after he pushed her down, he destroyed the cell phones and then threatened her if cops came back.
Yes.
Thank you. Officer Miller, were you concerned that he might come back?
Yes.
Did you do any safety planning with her?
Yes.
And did that involve see if there was another place she could go?
Yes.
Thank you. Your Honor, at this time, the people have no further questions for the witness.
Thank you. Cross-examination?
Yes, Your Honor, thank you. Good morning or good afternoon, Officer Miller. So you've been with Lansing Police Department for 3 years, is that correct?
Yes.
And I assume you went to the police academy, is that correct?
Yes.
You were trained to take an accurate investigation, is that correct?
Yes.
And you were called out to 221 East Hillsdale on June 7th of this year, is that correct?
Yes.
That was the first time on June 7th you've been to that residence, is that correct?
Yes.
And while there, you came into contact with two people, Warren Jones and my client's grandfather, is that correct?
Yes.
Did anyone take the statement of my client's grandfather?
I believe Officer Cutler spoke with him.
You personally did not. is that
I did
correct?
not, no.
Okay.
Are you able to spell the last name of that officer for the record?
Cutler.
And you said that you had And to your knowledge, that despite them having the same name, they were not married, is that correct?
Yes,
And you took her statement that day, is that correct?
yes,
And you said subsequent to that date, you'd been out to that home, is that correct?
yes,
But that was something unrelated to anything in regards to Lauren Jones, is that correct?
correct.
You didn't, since this time, and besides testifying here today, done anything else in regards to this case? Any further follow-up work since, besides coming to court today?
No.
And you said you thought he had gone down to Jackson, Michigan, is that correct?
That's what the victim stated.
Did you try to radio to Jackson to see if you could help get his whereabouts located?
No, because I did not have an address.
All right, no further questions for officer.
Can you redirect?
No, Your Honor.
May this witness be excused?
She may, Your Honor.
She may, Your Honor.
Okay, without objection, the witness is excused. You may leave.
Thank you. Yes.
Any further witnesses from the people?
Not from the people, Your Honor.
Any witnesses from the defense?
None, Your Honor.
Motion for bind over.
Your Honor, we believe probable cause has been met for each of the counts. Count 1, interfering with a crime report by committing a crime or threatening to kill or injure. As the defendant did retaliate, attempt to retaliate, or threaten to retaliate against another person for attempting to report a crime committed. He told her, cops are here, I'm gonna fuck you up. That's a clear threat, Your Honor, to retaliate specifically, or if she has the police come there. For probable cause burden, I believe that has been met for count 1. For count 2, he took the cell phone out of her hand and destroyed it, permanently depriving her of said cell phone. He intended for her to no longer have that phone. I believe that meets the burden for count 2, larceny from the person. Count 3, malicious destruction of personal property, between 1,000 or 20,000. She gave an estimate that the total cost, the aggregate of the laptop and the cell phone, was $1,500, safely being inside that range. Then count 4 is a misdemeanor, which is bound up automatically. Your Honor, obviously the biggest issue here is ID. However, I believe successful identification has been met. As the victim told the officer, this is a Tyrese Jones who lives here. Black male, dreadlocks. And then later, that same officer is back at that same residence and interacts with a Tyrese Jones, black male with dreadlocks, who is sitting here in this courtroom that she identified. And more so than that, in cross-examination, Mr. Feigelson stated, wasn't my client's grandfather at that home as well? Explicitly identifying the defendant as Tyrese Jones who lives there. I believe identification has been met for purposes of a preliminary examination. I believe all the elements of the 4 charges have been met, and I'd ask that you bind over accordingly.
Argument against bind over.
Yes, Your Honor, a couple of things to point out. Start with count 1, Your Honor, and I'd ask that count 1 not bound over. Where's the threat? Where's the attempt? The testimony was, if you call the cops, I'll do something to you, but that's an empty threat, Your Honor. He in fact had been living at that home and nothing had occurred. I'd ask that not be bound over, Your Honor. We're wasting everybody's time if that gets bound over. With regards to count 2 and counts 3, they're both the same fact pattern here. If you're gonna say he destroyed the property and he stole it, can't be, it's gotta be one or the other, Your Honor. I'd ask that count 2 be not bound over here today, Your Honor. You leave it to the courts and the rest. Thank you.
Thank you. In regards to the preliminary examination, this is a probable cause hearing. Probable cause is a lower standard than beyond a reasonable doubt. So court's decision is based on the testimony concerning the counts before it. In count 1, the count 1 is did Tyrese James Jones. First of all, as to identification, I believe identification's been made sufficiently, not only by the hearsay witness on the stand, which was Officer Caitlin Miller, but also in the testimony from that she testified to as to Lauren Jones, which would indicate that Tyrese James Jones is the person who did this, is the person in front of the court, made identification, indicated that they were in a relationship together, although they have the same name, they weren't married, and also indicated that she was carrying his child. So I think all those go to an accurate identification. Not only that, the officer said after the fact that they'd had contact with both individuals and that identification was made. So I believe the in-court identification suffices that this defendant is the person who committed the alleged counts. So in count one is for interfering with a crime report. There's plenty of evidence from the hearsay testimony to indicate that the defendant threatened the individual by saying that he would threaten her or hurt her in some way, did retaliate, attempt to retaliate, or threaten to retaliate, threaten to retaliate being the operative terms here, against another person for having reported or attempted to report a crime committed or attempted by another person by threatening to kill or injure a person. We can all debate what FU up means, but it definitely means count one. So I'm going to find that the probable cause has been proven, and I'm going to bind over on count one. Count two, larceny from a person, is more of a legal argument. The testimony is that did commit the offense of larceny by stealing from another person, to it Lauren Jones certain property, to it a cell phone. I believe the cell phone is a part of this. I also believe that the laptop is a part of this for permanently depriving. Finally, at the time it was taken, the defendant intended to permanently deprive the owner of the property. That was taken constructively from her possession and thrown in the middle of the street and broken. It seems to me that that would be an attempt to permanently deprive that person. So I would be binding over count two on cell phone and laptop. Count three, malicious destruction of property, 1,000 or more. I'd say that to both the cell phone and the laptop, this burden has been met by probable cause evidence, in that the injury was $1,000 or more to the laptop and the cell phone, as requested in count three. Count four, this is the misdemeanor count. There was an indication that Miss Jones was pushed. That I don't have to make that determination since this follows the three felonies. So I find by probable cause evidence that counts 1, 2, and 3 have been proven, and count 4 will follow for bind over to circuit court. And I will indicate that for the file that the examination was held on today's date and it was bound over as charged. Anything else for the record from the people on docket 22-01810, Mr. Pfeiffer?
Not from the people, Your Honor.
Anything, Mr. Pfeiffer?
Yes, Your Honor, the one request we would have is with regards to bail, Your Honor. He has a GPS tether on, Your Honor, and would ask that that be modified. He has limited expenses, Your Honor, and I know that that can be difficultly burdensome, coupled with there's no indication that he has any intent to have any contact with Miss Jones. I don't believe that having a tether on is necessary to protect Miss Jones from Tyreek here today, Your Honor.
Response?
One moment. 30 seconds. Your Honor, I believe that the GPS tether is doing its job as intended, keeping the victim safe. The fact that it is working is not a reason to stop that now.
But
especially in the fact that charges now been bound over.
Right. I believe now that they've been bound over to circuit court on 3 felonies and a misdemeanor, including the same victim. I believe that the GPS is working. There's a no contact order. I'm going to leave the GPS as effectively keeping the non-contact order. So the motion is denied.
Thank you, Your Honor.
Thank you. That's all for the record in docket 22-01810. Mr. Feigelson will contact you with your next date. Okay, sir? All right. Thank you.
Yes, sir. Thank you, sir.
You guys have a great day.
Commissioner, retrieve the exhibits, Your Honor.
Yes. There's 4 for your file.
Thank you very much.
Oh, yeah.
That is it for me today.
All right. Thank you, Mr. Pfeiffer.
Welcome. Last week I had 6 exams with Judge Ward. I was here from 8:30 to 4:30. exam was 3.5 hours long. Yeah. That's about known. Yeah. As GBH, not A1. Yeah.
Thank you, Mr. Feigelson. All right.
Have fun. Blowing your courtroom for the last couple of years.
Mr. All right.
No.
Yeah.
Father-in-law's coming to town for a funeral next week. All week.
So this is
Every damn time he comes up from Texas.
Mr. Robinson.
I'm getting Mr. Robinson. Thank you.
All right.
Have a good weekend, Your Honor.
You too. Thank you, Mr. Pfeiffer. And Mr. Witzy, we're going on Mr. Robinson when we get Mr. Yang's client.
That's right.
All right, thank you.
Are there any exhibits, Mr. Whitson?
No exhibits. I have 2 witnesses.
All right.
What is the court's preference? Would assume just bring the first witness in now.
Correct. We should check to see. Somebody. No? Is that the PA 53 that I just did, that you just did?
No, that one apparently is a Judge Ward case. I looked at it wrong, so she's gonna handle the warrant, so I just undid everything. I don't know what, yeah, they just sent that one to the wrong judge too. I don't know. I'm trying to figure that out.
Okay. Except for the one that you printed out for me, and I don't.
Well, I had them, they were emailing me from the jail. I was like, I assumed it was our case, and when I looked, the way that it was titled, I just misread it, that you were the judge that signed it, so the judge record.
Right.
Like stuff at it. Just probably why I shouldn't check the email or anything crap.
All right, we're on the record in docket 22-01726. People of the state of Michigan versus Jaquan Robinson. Will the parties please introduce themselves for the record?
Jake Westy on behalf of the people.
Good afternoon, Your Honor. Joseph Yang on behalf of Mr. Robinson, who is present and to my right.
And you are Jaquan Robinson, sir?
Yes.
All right. This is the time set for a preliminary examination today. Mr. Witsy, how are we proceeding?
Your Honor, the people are ready to proceed with the examination.
And Mr. Yang, that's your understanding?
Yes, Your Honor. Just to be clear, I believe no offer has been extended. Therefore, just to make the record clear, therefore, we are ready to proceed with the examination.
All right, thank you, Mr. Yang. So Mr. Witsy, you may call your first witness.
Call Officer Benjamin Bradenberg.
Okay, officer, I'm gonna have you stand up right here. And I'm gonna have you say and spell your last name for the court reporter.
Officer Benjamin Brandenburg, Brandenburg.
All right, raise your right hand. Do you solemnly swear to tell the truth, the whole truth, nothing but the truth, under penalty of perjury?
I do.
You can have a seat, sir. Thank you. And Mr. Witsy, when you're ready.
Thank you, Your Honor. Good afternoon, officer. Where are you employed?
Lansing Police Department,
And how long have you been employed there?
almost 5 years.
And what is your position at the police department?
I'm currently assigned to the Violent Crime Initiative.
And in that, what is your role being assigned to that initiative?
It's numerous duties, but we typically are assigned violent crime cases for individuals and do our investigations from there.
Were you working in your employment on June 29th of this year?
I was.
What were you doing that day?
I was alerted to Benjamin Davis Park by Officer Rick Samuel of MSUPD, who is also one of the members of BCI.
Where is Benjamin Davis Park located?
It actually touches two roads, but the area that I was in was Pleasant Grove, just south of Jolly Grove.
And is that in the city of Lansing?
It is.
Is that in the state of Michigan?
Yes, sir.
In that capacity, did you observe the defendant at all?
I did.
Do you recognize him to here today?
I do.
Could you point him out and identify something he's wearing?
Mr. Robinson is there, blue shirt over gray long sleeve.
May the record reflect the witnesses identified the defendant.
Without objection?
No objection for purposes of the preliminary.
Thank you. Without objection, the witnesses identified the defendant.
And had you had any prior interactions with the defendant?
Interactions personally, no.
You had any prior knowledge of the defendant?
I do.
What was that?
So typically throughout the course of our duties, we prepare workups, which are essentially intelligence we've comprised of certain individuals and their associates as it pertains to violent crime or crimes, basically to help us get a better grasp of who people are, where they associate, vehicles of that nature. And I had observed a previous workup from Mr. Robinson, as well as completed one myself.
What did you learn from that workup?
His height, weight, he has a pretty distinct tattoo across his chest, as well as associates too.
Objection, Your Honor. This answer calls for hearsay. He explained this is a workup. It wasn't his own personal knowledge. It was a workup. He had no contact prior to this incident with Mr. Robinson.
Response?
This is leading up to asking why he was able to recognize him when he saw him in the park. So it goes to the effect on the listener, not the truth. of the matter.
So I'll find it not offered for the truth. It's not hearsay. You may continue.
Thank you, Your Honor. So based on what you learned in the workup, when you saw the defendant on the park, were you able to recognize him that day?
I was.
Did you know how old the defendant was?
I believe he is 19 years of age.
Did you know him to be on any sort of a probation or parole type status?
Yes.
What was that?
Currently height of probation, based on the prior incident. Relevant, but the probation status is still currently active.
Right, Mr. Westy, and I'll have you raise your voices as much as you can.
I'm sorry, he was currently on the height of probation, yes.
Objection, again, Your Honor, just this calls for hearsay. This information that he was provided by either somewhere else or some other, it's not his personal knowledge. This calls for hearsay.
Okay, in response?
Again, this is effect on the listener, Your Honor.
Right, so it's not offered for the truth. I won't take it as such. So the objection's overruled. And then I just ask both parties to raise your votes.
Thank you, Your Honor. What did you observe the defendant doing that evening?
Observed him playing basketball at basketball courts at Davis Park. At one point, I saw him approach a Buick sedan in the parking lot, which was maybe 50 to 100 feet from my vehicle that I was in. Observed him retrieve, actually several times, holding onto a large object in his left pocket. They are basketball shorts. Sorry, I'm motioning left pocket, but basketball shorts, so it's pretty obvious. It's a fairly large object, larger than a cell phone. And typically when people walk with a handgun or some type of weapon, their hand never leaves it. It's known as a security touch. That's in a sense to make sure that the object is still there and remains where it is. So I observed those actions several times as he's walking towards the vehicle while he's speaking with, I believe it was 3 females and the driver of the vehicle. I couldn't tell if that was male or female. He removes a black handgun with a silver slide from that same pocket, shows it to the driver, shows it to the females, then turns his back to me and walks back towards the asphalt courts.
Do you have any reason to think he may have a concealed weapon license?
He's unable to have one as he's 19 years old.
After you saw him show that gun, what did you see him do next?
He walked over back towards the basketball courts, comes back with a backpack to a blue pickup truck, which is parked just a little bit farther into the park from where the Buick was. Has the backpack, still has the firearm in his pocket, gets into the black truck or the blue truck, comes back out, and then exits with the backpack to the southeast portion of the parking lot. Comes back with the backpack, firearm's no longer in his pocket, from what I could see.
You no longer see him exhibiting those carry motions, as you call them.
The armed behaviors were not present anymore on him when he returned with the backpack. He gets into the front passenger seat of a silver Mercury Mariner, I believe. I don't quite remember the license plate, but relay all this information, the backpack, the previous armed characteristics, and firearm observed to our additional plainclothes surveillance and marked officers. Obviously, we don't follow them out initially because I'm still in an unmarked vehicle. He's observed leaving. After that, I can't testify to what was observed or I was not present for any of the other interactions.
Did you come back in contact with him later that day?
Yes.
You were not present for any of the interactions when he was driving in the vehicle. Is that your testimony?
No, not when he was inside the vehicle. No.
But it came to your knowledge that he was pulled over at some point.
Yes.
And at that point, were you on that scene?
Yes.
About how much time had passed?
Say maybe 20, 25 minutes.
And when you arrived at that scene, did you come in contact with the defendant again?
Not initially. Initially, I was called there to observe a silver backpack left in the front passenger seat where I observed Mr. Robinson enter.
Did you observe that backpack?
I did.
And this backpack did it match the backpack you saw him with earlier?
Yes.
When you observed the backpack, what did you see?
Officer Zistman, or sorry, Sergeant Zistman of the Michigan State Police opened the backpack. Based on my observations and fleeing, there was 2 firearms located inside, one being a black firearm with a silver slide. I believe the other one was just black. But after that, made contact with a couple other occupants in the vehicle. Then when they were able to get Mr. Robinson in custody, obviously it's the same person I observed.
No further questions, Your Honor.
Cross-examination.
Thank you, Your Honor. Good afternoon, Officer Brandon Burke, correct? All right. I represent Mr. Robinson. If you need me to rephrase or speak up, just please let me know. All right. So you said you're currently working with the VCI, is that correct?
Yes, sir.
And that day, were you in plainclothes capacity or uniform capacity? Plainclothes capacity. And earlier you stated you were observing the basketball court, is that correct?
Yes.
About how far were you again from that?
From the basketball court, maybe 150 feet, 100 feet.
Were you in a vehicle, outside of a vehicle?
Inside.
Okay. And did that vehicle have a tent at all?
No.
You don't have to tell me the make or model. Is it an SUV or like a 4-door or sedan? What exactly is that?
Classified as an SUV.
Like an SUV? Okay. And so you're familiar with the layout of that portion of Benjamin Davis Park, correct?
Yes.
Because Benjamin Davis kind of goes from Wise all the way to Pleasant Grove.
Yeah, 2 branches.
All right. And so where in that parking lot were you actually parked?
So southeast portion before you get to the basketball courts.
Okay, so were you closer to the bathrooms over there?
No.
Okay, were you closer, I guess, there's the basketball courts, then there's kind of the grass right before that, is that correct?
Yes,
Were you, how close to that grass were you?
I'd estimate maybe 30 feet, 40 feet.
Okay, so you were in the
In the first few parking spaces. away from-
first few parking spaces towards the sidewalk area where the walkway is, or in the middle of the lot?
No, not in the middle, more towards the sidewalk that's the closest possible.
And were you backed in or were you parking forward?
Pulled in the rear of the vehicle.
So you were in the rear vehicle observing? Okay. Is there a tent in the rear of the vehicle?
In the rear there is.
Okay. Do you know what capacity of the tent that is? All right. And did you observe with just eyes or did you have any other, you have binoculars? Okay. And so do you yourself have any corrective vision, either glasses or LASIK or anything like that?
I had LASIK probably 6 years.
All right. And you said that when you observed that, earlier testified that you observed a firearm, a silver firearm. Is that correct? Would you be able to make out the make or model or anything like that? Not from that, okay. And so when you testified that Mr. Robinson was coming to and from the basketball court, were the vehicles still in the parking lot or were they in the grass area?
There was a few in the grass, but the ones he was approaching from the parking lot. Maybe 4 spaces to the south of me, and then the truck, maybe another 3 to the south of that.
Okay. Does that vehicle have any dash cam or any type of surveillance, audio, video recording devices? No.
No.
Did you have any audio or video recording devices on your person?
Not at the time. I do have my best. It was not on.
It was not on time. When did you put that on?
When I got to the scene of the traffic.
Okay. Earlier, you guys stated that you observed what you categorize as a large, heavy object in his pants. Is that correct?
Yes.
Well, you can't confirm 100% that that was a firearm, though.
No.
Okay, so it could have been a cell phone. It could have been a battery pack, anything that was large and heavy, correct?
Absolutely.
All right. And earlier you testified that you saw Mr. Robinson have a backpack. Did you ever see him put anything in that backpack?
No.
Okay. So he just had the backpack, is that
Yes.
correct? So the vehicle that Mr. Robinson eventually gets into, I believe it was the Mercury. Did you see any of those occupants enter into that vehicle at all?
Yes.
Okay. Did any of those occupants have backpacks at all? To your recollection?
Additional black backpack.
Okay. Did you observe anything on those occupants that might have looked like large, heavy objects at all? Okay. Did you know any of those other occupants besides Mr. Robinson?
I know the driver. Yes.
Okay. And about how many occupants were in that vehicle, if you can recall?
I believe there was 5.
5 total? Okay. And earlier you said it took you about 20 or 25 minutes to arrive from Benjamin Davis to the traffic stop. Is that correct?
Yes. So, and you'll
Yeah,
explain why.
yes.
So it's not that far of a drive to get there, but the passenger of the vehicle, front seat passenger had fled. So I was assisting with trying to locate that person. When they advised the backpack was still in the vehicle, then they called me over to see if I could identify him.
Okay, so you didn't follow initially, you were doing something else and then came back to the traffic stop.
Yes.
Okay. When you came to the traffic stop, did you have any markings of officers or any, like a vest or anything like that?
Yes, I put my vest on.
All right. So when you're asked to come identify that backpack, your testimony was about 20, 25 minutes before you actually saw the backpack. Is that correct?
I saw it 25 minutes prior to everything.
Correct. So from the time that they left Benjamin Davis.
Yes.
Till you seeing the backpack was about 25 minutes, correct?
Probably. Yes.
Okay. Okay. So you don't know where the backpack was in between that time. Is that correct? Okay, so you can't testify as to who had it, chain of custody, whether it was moved, anybody moved it, or anything like that, correct? All right. And your testimony earlier, you said Mr. Robinson had gotten into the vehicle. Do you remember where in the vehicle he had gotten into?
Front passengers.
Front passenger seat. Do you know if, did you observe anybody changing positions or anything like that in the brief time that you observed that?
I believe the rear passenger seats were, three occupants in the rear were moving, but I think I was sitting where they were gonna get out.
So you saw, I guess the term is further movements kind of moving around.
No, I would say like picking out who was gonna sit near the window. is
Okay.
what I observed.
All right. So there was some movement in the vehicle. Is that correct? All right. But you couldn't make out what exactly what was happening in the vehicle.
I think the doors were open, so I could see them just picking their seats.
Okay. And were all the occupants of that vehicle playing basketball that day as well?
I believe so. Gentleman with the black back, I don't think I ever saw it. Yeah, well,
One moment, Your Honor.
Certainly.
No further questions, Your Honor. Thank you.
Any redirect?
Just briefly, Your Honor. Officer, so it was 20 to 25 minutes between the time you saw the vehicle leave and you arrived back at where the vehicle had been pulled over, correct?
approximately.
The reason for that was, what was the reason for that?
So I'm currently in the back seat of the vehicle, which takes me a little time to get, I'm not small, seat to get up there. And they'd already made the traffic stop, so obviously I'm not driving fast to get there.
You didn't go there immediately to the traffic
No.
stop. Where
They
did you go?
advised someone fled, so typically with one police, we spread out to try to assist with maintaining a perimeter, so that took us long.
How long was it between when you saw the vehicle leave and you were informed the suspect had fled?
Followed it for probably maybe 5 minutes, 5 to 10, so maybe around that range, it was pretty immediate, because they tried to make the traffic stop.
No further questions, Your Honor.
May this witness be excused?
Yes, Your Honor.
Without objection?
Yes, Your Honor.
All right, this witness is excused. People may call their next witness.
Calling Officer Tyler Tenbrink.
Thank you.
Officer Tenbrink. I'm gonna have you stand right here, and I'm gonna have you state your name and spell your last name for the record. Here's right here, just so she can hear it.
Tyler Tenbrink, TYLER TENBRINK.
All right, so I'm gonna have you raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right, sir, have a seat and keep your voice up for recording purposes mostly. You may proceed, counsel.
Thank you, Your Honor. Good afternoon, Officer. Where are you employed?
Yancey Police Department,
How long have you been there?
approximately 4 years.
And were you working on July 29th of 2022?
Yes,
In your capacity of your employment, did you come across the defendant Jaquan Robinson?
yes,
Do you recognize him here today?
I do.
Could you point him out and identify something he's wearing?
Gentleman, the defendant wearing the blue jumpsuit.
May the record reflect the witnesses identified the defendant.
And without objection?
No objection for purposes of the prelim.
Okay, without objection, the witnesses identified the defendant.
How did you come into contact with Mr. Robinson on the 29th of June?
So working with VCI, I'm assigned to VCI, the Violent Crime Initiative, Lansing Police Department. I was working in the capacity in a marked police vehicle. Officer Brandenburg advised he was watching some individuals at the Ben Davis Park off of Pleasant Grove.
Objection, Your Honor. I understand this is foundation. I just want to make sure it's not for truth of the matter asserted, but just for foundational.
Fair enough, same
Same response, Your Honor.
So it's not offered for the truth, it's only offered to indicate how the situation got within his presence?
Yes, Your Honor.
Okay, so with the objections overruled.
And also Brandon was watching some individuals at the Ben Davis Park on Pleasant Grove. Advised that he saw Jaquan Robinson, who he is familiar with, at the park, displaying some firearms. Officer Brandon advised that, Mr. Robinson got into a Mercury Mariner vehicle, in the front seat. That vehicle then took off, left the park. I was in a marked patrol vehicle trying to catch up to the vehicle. I was advised of some traffic violations that the vehicle was committing.
I just want to check specifically to the traffic violations that he was advised of that specifically.
Again, effect on the list.
Right. The objections understood, the response, the objections overruled as to just not offer for the truth, and you may proceed.
As I got closer to the area where the vehicle was, the vehicle then turned into 900 West Edgewood apartment complex. As I turned into the complex, I saw the vehicle stop just by the mailboxes. As you come to the entrance, I initiated a traffic stop with my emergency lights. There was one individual that got out of the vehicle, started walking behind the vehicle, and I just advised him to stop. And then I observed another male near the front passenger seat, stand there for a second and then take off running northbound through the complex.
And who was that male who took off running?
The male I saw at that time exactly was a black male, no t-shirt, slower build, a little taller. Subsequently was found by Michigan State Police trooper, canine trooper, and other officers from the License Police Department. Was brought back to the scene and was identified as Jaquan Robinson.
That's the same Jaquan Robinson here in court today.
Yes.
Did any of the other occupants of the vehicle flee?
No.
No further questions, Your Honor.
Any cross?
Yes, Your Honor. Officer Tenbrick, my name is Joseph. I represent Mr. Robinson. I'm going to ask you a few questions. If you need me to repeat or slow down, just please let me know. Okay. All right. So when you received the call, did you put lights and sirens on immediately, or did you do that after you already entered the parking lot?
As I got into the parking lot down Harding West Edgewood, I initiated a little bit into the parking lot, I initiated my emergency lights.
So how long had you been following the vehicle prior to entering the parking lot?
I was trying to catch up to the vehicle. The vehicle left from Ben Davis Park off of Pleasant Grove. And then went down to Edgewood. And then went east on Edgewood and then back west on Edgewood. I would say maybe a mile or two, possibly.
Were you the immediate officer behind that vehicle at that time for that mile or two?
I did not catch up to that vehicle until we got into that parking lot.
Okay, so just to confirm, you did not see any traffic violations that
No,
were
I did
called
not.
out? They were only called out, is that
Yes.
correct? All right. So you said once you arrived in that parking lot, there was already a person outside the vehicle?
As I was pulling up towards the vehicle, there was an individual that got out since they did stop at the mailboxes and was walking behind the vehicle.
Okay, so prior to them stopping, you can't definitively say who was sitting in which position, is that correct? Prior to them stopping, did you observe the vehicle and which passengers were in which part of the vehicle?
No.
No, so, but by the time you made your first observation, there was one person outside the vehicle already, is that correct?
Yes.
All right. And did you confirm that person was actually one of the passengers of that vehicle?
Yes.
Eventually?
I saw him exit the vehicle.
You actually saw him exit the
Yes.
vehicle, all right. Did you author a report for this case?
Yes.
All right. And is it fair and accurate to the best of your ability at recollection at the time? Do you remember?
Yes.
All right. And earlier you got testified that you actually saw the front passenger exit out of the vehicle. Is that correct?
I believe my report reflects that I saw somebody near the front passenger side of the vehicle.
Okay.
But I have to look at my report to refresh my memory to be completely accurate.
If you think that'll help refresh your memory, I can try to do that. Oh, okay. Your Honor, if I may approach the witness.
You may.
So I'm going to show you your report. Please don't read from it out loud. Just look at it, and when you think your memory has been refreshed, please let me know. We'll move forward with questions, okay? All right, so let's start right there. Officer Gray, Officer Tenlinks. So under the.
Let the record reflect that both counsel have indicated what was shown to the officer to refresh his memory.
So
Is that
Officer,
true?
Yes, I reviewed that. I have no objection. It's,
Okay.
I can put it on the record.
No, I'm just making sure that you guys, I didn't get to see what was on the left, so I want to make sure that everybody's talking about the same police report.
yes, Your Honor.
All right.
I did confirm with the people, and it is the same police report.
All
We
right.
have identified the exact location, so.
All right, you may
Um,
proceed.
So Ms. Tenbrick, has your memory been refreshed?
Yes.
Okay, and in your report, what did you indicate that you observed?
I observed one male exit the vehicle, walk around the vehicle, and then I observed a male standing by the front passenger side.
So based on your report, he was already outside the vehicle as well then?
I can't say for sure because I was dealing with one individual
The
that
one
went out
that was-
first.
Okay,
So I can't say that, but I did not see anybody on my approach up to that outside, standing outside.
all right. Do you have any dash cam on your vehicle?
There should be, yes.
Okay, do you know if it was activated? Does it automatically activate, or do you have to manually activate?
It should automatically activate once the lights come on.
Okay, so, but your lights didn't come on until you entered the parking lot, correct?
That, yes.
Okay, so there would have been nothing from the prior, perhaps mile and a half that you had said you were trying to catch up?
No.
Okay. And did you help in the search of the vehicle at all?
No.
Okay. No further questions, Your Honor.
Can you redirect?
No, Your Honor.
May this witness be excused?
Yes, Your Honor.
Without objection, the witness is excused.
Thank you, sir.
Any further proofs from the people?
No, Your Honor.
Any proofs from the defense?
No proofs from defense, Your Honor.
Make motion for bind over?
Yes, Your Honor. I believe that the probable cause standard has been met on both counts. We heard testimony from Officer Brandenburg that he observed the defendant with a gun, saw him with a gun in that park, then saw him leave, come back with a backpack. It appeared he was no longer carrying the gun. He left in a vehicle. That vehicle was stopped somewhere between 5 to 10 minutes afterwards. And then Officer Brandenburg arrived there, found the backpack matching the description. The backpack was in the passenger area where he said he observed him getting into the vehicle. And then on top of that, you have testimony from Officer Tenbrink that the defendant was the only person who fled. That shows evidence of guilt, that shows evidence of knowledge. I believe that both counts are met because there are two weapons here. The elements are basically he had a weapon concealed, and that he had knowledge of it. I think that if it was in a backpack, it's concealed. I think if he has knowledge of that, that's implied there. There's also an alternative theory that it's concealed in he has a weapon in a vehicle. I think it's also been shown probable cause on that theory based on the facts.
Thank you. Response to motion for bind over.
Thank you, Your Honor. At this time, I'd ask that you dismiss both cases, both charges in this case. I guess I just want to start chronologically. That kind of helps me make sure that I don't lose track as well. There was testimony that he had observed a firearm, but there was no testimony that he observed a firearm going into the vehicle, just that he entered the vehicle with a backpack. Doesn't know what was in there. All right. In addition to that, there was testimony from both officers that there was about 5 occupants in that vehicle. Nobody besides him entering the vehicle at Benjamin Davis Park. There are 5 other occupants in the vehicle, and there's no telling what was or was not in that vehicle at that time. In addition to that, there's been no testimony, independent testimony or observation of any traffic stops. Without that, this was an illegal traffic stop. There was no independent. The person who had called out these was not here to testify as to what they observed, to provide a separate foundation for the probable cause for the traffic stop or for the reason for the traffic stop. In addition to that, there's no testimony as to how the vehicle was searched, why the vehicle was searched. Just basically, backpack was found, there was a gun inside there. So at this point, Your Honor, I would ask that both counts be dismissed as probable cause has not been met here. The people have not met the burden, have not even gotten to the stop, gotten a stop and gotten into the vehicle. So therefore, both counts should be dismissed at this time.
Thank you,
Your Honor.
Thank you, Mr. Yang. Any response?
Just briefly, Your Honor, I believe there's certainly enough evidence to meet the probable cause standard here. Defense has not brought a motion to challenge the validity of the stop. I would question, even if as a passenger he has any standing to challenge the stop. I think there's enough evidence here presented to bind him over.
Thank you. This is the time set for preliminary examination in the matter. And so I will look at the probable cause standard for preliminary examination purposes is probable cause to believe that a crime has been committed, probable cause to believe the identity of the person who committed that crime. As to the location, offense, venue, ID of the offense between the two witnesses, which are the last witness was Officer Tyler Tenbrink and the first witness was Officer Benjamin Brandberg. This occurred on June 29, 2022. Initially at the park was what Officer Brandenburg talked to. The stop was actually made at 900 West Edgewood Boulevard, City of Lansing, Ingham County, State of Michigan, for purposes of date, venue, and location. Identification was made by Officer Brandenburg in regards to identity of the individual in the crime. And so we'll look at the pre aspects, which was that Officer Brandenburg recognizes the individual, seeing movement and gestures, which would indicate that he was carrying a handgun. Lost track for 25 minutes. The car was stopped. In the car with the same backpack that was initially seen when the defendant moved into the car in the Mercury Mariner and then flee from the car. The backpack, which was associated with the defendant by witness testimony. I find that at a probable cause standard, which is the second lowest standard in criminal law, that the defendant, Jaquan Montel Robinson, did carry a dangerous weapon. To it, the first one was a pistol. That's the silver slide concealed on or about his person, and whether concealed otherwise in a vehicle operated or occupied by said defendant, that was found in the Mercury Mariner in the backpack. So I believe that is where the vehicle. So I understand the nature of the charging, both on his person, by the backpack, and then found in the Mercury Mariner. So I believe there's probable cause to bind that count to circuit court. I also find in count 2 the second weapon, which is the Sig Sauer 320 or a pistol concealed on or about his person, and whether concealed or otherwise in a vehicle operated or occupied by said defendant, or as a passenger to it, a Mercury Mariner. Also, that was in the backpack of the vehicle in which the defendant had fled from. Backpack was associated with him through a prior witness. Both weapons were found in the backpack that he fled from. Therefore, I found at a probable cause level that both counts have been proven by probable cause, and I will bind both counts over to circuit court, where the higher standard of beyond a reasonable doubt is required. But for probable cause determination, both counts are bound over as charged. Anything else from the people in regards to docket 22-01726, Mr. Wisty?
No, Your Honor.
Anything, Mr. Yang? Nothing further on the defense,
All
Your
right,
Honor. Thank
all
you.
right, thank you. And sir, keep in contact with your attorney, Mr. Yang, and he will tell you the next date in circuit court.